So I think we are going to go ahead and get started. And let me say in the classic Texas A&M way, howdy. And you all responded absolutely appropriately. Good one. So delighted that you're here today. I'm going to have a few words to say, but first of all, we have a welcome from our dean, Ahdieh.
Welcome, everyone. I'll say howdy as well. Howdy.
You need to project.
I tell the story of, okay, so where is it?
It's right here.
Oh, I know it. I see the things which my ear broke. Let me say, it's very hard for me to stay in one place. This is a very like painful thing for me. The storyteller of howdy always is, I think I've been here, my second year here. So I've been here this summer, it'll be 6 years. It was my second year here. Was an event in Dallas at the Dallas Bar Association's building or offices. And it was a luncheon event in which they were giving out summer scholarships to students from the state, I think out of state, at least state of Texas, who were going to go do public interest work in the summer. So they give out 4 of them to basically give them some funding for the summer. Dallas has been for a very long time kind of owned, for lack of a better word, by SMU Law School. God bless, great law school, et cetera. So when everyone arrives and opens the program, they're somewhat shocked to see that there are 4 reward recipients. Two of them, unsurprisingly, are students at SMU Law School. 2 of them, bizarrely, are students from here. Folks, so look, where's UT? How the heck does A&M have as many as SMU? Because this is the Dallas Bar Association. So anyway, okay, it was fine. It was a little bit weird, but I mean, people were surprised, but it was fine. The first speaker, each of the award recipients is going to get introduced by a member of the bar. I think it was a member of the committee, the selection committee. So a guy goes up to the microphone. He is not an Aggie himself, and he's going to introduce the first of the 2 Aggies, 2 A&M law students who are getting it. So he comes up to the microphone and he goes, "Howdy." And it's a big room. For those who've been there, it's about 400 people sit in the room. And 6 of us were like, "Howdy." In response, and so he kind of looked down, he looked up at the crowd again, and he said, "Let's try that again." And he said, "Howdy." And this time maybe like 30 people were like, "Howdy." A little bit. So he looks down, looks up again. And he goes, "Friends, I am introducing what I suspect will be the first of many, many students at A&M Law School who will be recipients of this honor and recognition." He said, "Unless you all cooperate, it's going to be a very, very long afternoon." Let's try this one more time. Howdy, and 400 all responded with howdy. So that in some ways is emblematic, really, of kind of what is exciting about what's happening here at A&M. These days I begin, because especially if we're doing this room, you look out and there's a crane carrying some nonsense. Across the front of the window. We are with significant university support, A&M system support, community support, industry and private sector partnership support. We are now building this incredibly exciting new campus here around the law school. It is for us narrowly defined. It's a great opportunity in the sense of these facilities. While we have done all we could with them, obviously there is a limit to what you can do with a former Southwest Bell switching station building. So for law school narrowly defined, it's a great. In that narrow sense, we'll be in better facilities. But more important than that, in many ways, is this campus is going to enable us to bring engineering and health sciences and agri-life and business school and other programs into our orbit or into this campus, which, given the interdisciplinary nature of the business that we are in now, that law has become, will just create opportunities, not just with the faculty and the students and the staff who are here, but in terms of attracting others who want to engage in that interdisciplinary venture that really is emblematic of what the legal scholarship and the legal profession, really broadly defined, are now engaged in. So we're excited about that. The construction you see out there is the first of 3 buildings. That building is called the Law and Education Building. There'll be about half law school space, and the other half will be engineering and some health sciences and some other academic programs, but straight academic programs. Then I hope within, let's call it a year or so, year to year and a half, we'll break ground in a second building, which will occupy some portion of These other two parking lots here, that's called the Research and Innovation Building. The law school will also have some space in there, but it'll also include, in addition to the academic partners, space for private sector and community partners to also come into the building. So we're talking to various law firms, healthcare companies, engineering companies. And again, now think about, add to the, it's not just law, it's also engineering and health sciences and agri-life and other things. Add to that now companies that do that work, including law firms, including, the local bar association. We're talking to them about being in the space as well, with an eye to, again, creating more opportunities for students, more opportunities for faculty to be able to engage more robustly. So that'll be a second building. Once that's built, we'll be able to vacate this building. And then the plan for this building is a combination of kind of more of the same, but also what we think of as high-end convening spaces. So spaces that will allow us at a much higher level, more sophisticated level to host big lectures. We talk about like TED Talk quality auditorium, executive education center, conference center. That is as good a kind of point of reference to a second element of what has made us successful, and that's exactly what we have in this room, right? So prior to this is from the get-go, and maybe even I would say even as Wesleyan, there was this interest in being a convening place for engaging some of the most challenging questions of the day, some of the most interesting, consequential issues that we're facing locally, nationally, and internationally. And so having the space to be able to do that at an even higher level, an even better level, means a lot to us, but not just for us. It means that we can bring to the campus, we can bring to our community more of that as well. So that is another part of why we've seen the success we've. I mentioned the students already, so I'll say a little bit more about them as well. It is a completely almost unbelievable kind of trajectory in terms of who our students are now. I'll give you kind of on the front end the number that probably captures it most starkly. When Texas Wesleyan, when this law school went from Texas Wesleyan and became part of the A&M kind of system, A&M University, at that time now, coming on 11 years ago, we're celebrating the Aggie-versary. This year, the 10th anniversary of that acquisition in the summer of 2013. At that time, the median GPA of incoming students was a 3.09, right? So among the lowest in the country. This year's 1L class, it's a 3.97 is the median. So it means half or more of the class had a higher than 3.97 GPA. And I said, as deans will oftentimes have occasion to say to graduates something to the effect of, none of us could get into the law school today. I say no one can get into the law school today. We don't even know the students we think are actors, that have been hired to be here, given that who the hell has those grades. So the quality of students is incredible. And that in turn, in conjunction with, and I'm going to close with some comments on faculty, in conjunction with the high caliber faculty and the programs and the teaching that they're doing, it means that on the back end, we're likewise seeing tremendously amazing results from our students. They're hardworking, they have great faculty who teach them, who engage them. And the result of that is that we've seen great results on the back end as well. On the bar exam, the law school is now, this past year was #1 in the state of Texas in terms of bar passage, which is a great result for our students, not just in the sense of yay for you, but look, the best predictor of ease of getting a job is passing the bar, right? And so if that's high, then that helps with it. And that, of course, then has meant that. So on employment, likewise, we've seen great results in terms of high rate of employment of our students as well. So great results with the students. Last one, I'll just say a couple words about in terms of what we're excited about. And again, it ties into what you're seeing today, and it ties into particularly the dispute resolution group. We have really had I'm going to say the privilege or the honor, the opportunity to bring together this incredible array of faculty that started with the strong foundation that we had on the front end in terms of the faculty who had been with the law school prior to the acquisition and have remained with us. And then we've been kind of on this, I think it's fair to say, rather aggressive effort to go out into the world and recruit faculty, and faculty who will elevate the scholarly visibility of the institution, faculty who will be incredibly effective in the classroom in terms of setting up our students for success, faculty who will engage issues of the day in the media, in legislative work and regulatory work, and faculty who will engage all of you, right? Who will engage colleagues around the country. Ultimately, again, students are our lifeblood in many ways. But if you talk about the caliber of an institution, the caliber of a higher education institution, the faculty drives that more than anything else. So I'm honored to sort of have the faculty here as my colleagues. We have done that in I think a thoughtful way. Some of the hiring is broadly, we're going to go out and find great people. But a great deal of it is, let's think about what are areas in which there's opportunity. And dispute resolution has really reflected that very much. We have this incredible group of faculty led by Nancy, but including, just in the room, Cynthia, Peter, Michael, others, who really are, engaged. I include Bob in that as well. Who are, just on the front lines of engaging. What are the most critical questions and how we can contribute to them? So I'm excited to have you all part of that too. You're all our colleagues now as well. By virtue of being here with us. We hope you'll continue to be that. Again, if this is your first time here, welcome for this occasion. If it's your second time, keep coming back. Because again, we really are, I think, building something special, and not just for us, and not just because we fly a big Aggie flag up from a crane, but because again, we want to contribute to bettering education, to bettering knowledge, to advancing knowledge around these issues, and dispute resolution is as important a one for us to figure out as anything else. So thank you for being here. I appreciate it, and we're grateful. Please come back.
Thanks very much, Bobby. Really appreciate it, and very much appreciate the support that he has provided, and that the school generally has provided to the dispute resolution program and the coverage of dispute in particular. So I've been told two things. I need to be sure to project, so I'm hoping that I'm loud enough. And then secondly, I need to make an announcement regarding CLE. And if you give me 1 second, I will now make that announcement. And Cliff, am I being loud enough?
You might need to move over to the podium so the camera can.
Okay. Here? Okay. I'm working on following directions. Okay. So CLE information. There you go. Okay. Texas A&M School of Law as CLE sponsor will submit CLE attendance to the State Bar of Texas by March 31st for all verified attendees in person or online who are members of the State Bar of Texas and registered with their valid Texas Bar card number. I also have a disclaimer that I need to add, and that is, while some of the presenters are attorneys, they will be discussing the law generally, and nothing in the webinar should be considered as legal advice. Attendees should consult their own legal advisor to address their own unique circumstances. All right, so now I have gotten that little bit of business out of the way. Hello, welcome. We're very glad to see you here. I'm going to say a little bit about dispute resolution here at Texas A&M. Want to say a little tiny bit about the kinds of things that we all are involved in. Bobby has mentioned the faculty who are part of the dispute resolution program. One of the things that I think makes our program really unique and special is the degree to which, number one, we have such depth in terms of our faculty. Cynthia Alcon, Peter Riley, Michael Green, Guillermo Garcia Sanchez, Colin Rule, Bob Probasco. We have tremendous depth. And in addition, many of the faculty have their feet in both the field of dispute resolution and also a substantive field, which I think is quite exciting for us. So Cynthia focuses in the area of criminal law as well as dispute resolution. In the merger of those is plea bargaining. Peter Riley also focuses on criminal law and dispute resolution. Current merger of those is often in connection with deferred prosecution agreements. Michael focuses on the area of workplace law and dispute resolution, mediation and arbitration all over the place in terms of workplace law, right? Bob Probasco focuses on tax. Where's the relationship between dispute resolution and tax? Does the IRS negotiate? Well, yes, in fact, they do with our students in a clinic who have been very successful in representing clients. We also have adjuncts who are in the room. So Karen Washington teaches mediation and is a very well recognized mediator and arbitrator. Kate Elliott, I'm not sure she's in the room yet, but she will be, is another adjunct and somebody who also is very involved in coaching our students in connection with competition. So faculty. We have a tremendous depth in terms of faculty, and I haven't even mentioned some. Colin Rule, for example. As part of this, we also have a real depth in terms of courses. Negotiation, mediation, 2 different variations on negotiation, international commercial arbitration, domestic arbitration, lots of different courses, and a concentration in dispute resolution. And I'm also really proud that we offer an annual symposium. There are only a few law schools in the country that I think at this point where you can count on an annual symposium that is going to look in depth at an issue that's important in our field. And we are one of those. And I'm also really proud of the fact that today we are going to be focusing on mediation. The presenters and a few of us had dinner last night, and I said at that time that in a way I felt like today's symposium was a gift to me personally because I've been involved with the procedure of mediation for a very, very, very long time. I was introduced to this procedure by Frank Sander, who I know is somebody who was beloved by many of us in this room. I happen to know that one of our presenters named one of his daughters Sander, in part because of his feeling about Frank Sander. So what I'm going to do is a little bit of a setup of mediation that will be a combination of kind of overall history of mediation. And it's also going to have little bits of personal history regarding my role or place in this history of mediation as well. So let me kind of get started with that. Mediation's been around for a really long time. A really long time. It's in the Bible. Basically. And even in colonial America, mediation was used in order to resolve disputes between property owners and business people. It's been around for a really long time. In a way, though, I would say that we became more aware of mediation in the early 20th century as we had the Industrial Revolution, lots of immigration, lots of growth within the United States, lots of labor strife, lots of strikes. And then a perception that as a result of all this unrest, there was a threat really to the US economy. And in part, as a result of that, we saw that mediation was actually institutionalized in the labor area. Mike and Lisa would be able to speak much more significantly regarding that. But I think that's an important part of our history of the mediation process. And I'm saying that because then in the late 20th century, we had the contemporary mediation movement arise. And many of us, and I'm going to put myself in that group, many of us actually didn't realize the degree to which we ought to be looking at the history of mediation from the early 20th century, the ways in which it had been originally conceptualized, the ways in which it had been institutionalized. Why did mediation arise in the late 20th century? Well, again, we seem to have a period of a lot of social strife. The rise of the baby boomers, objections to the Vietnam War, concerns about civil rights, the deaths, assassinations of Martin Luther King Jr. and Robert Kennedy, lots of social strife. And at that point as well, you found people saying there are problems and we need to do something about it. What was one of the things that was proposed? It was mediation as a way to help people be able to talk together and maybe come to some sort of resolution. As I say those words about what the world looked like in the late 20th century, some of the same nouns and adjectives come to my mind as I describe what we're going through right now. I'm not sure, however, that the word mediation is coming up as frequently right now as a way to address some of the issues that we feel like we're dealing with. Hoping that we'll be able to talk a little bit about that today during this program. Back to the late 20th century. So 1987 is when Texas was one of the first states to adopt its ADR Act that institutionalized mediation and other dispute resolution processes in our statutes and actually gave judges the authority to be able to order parties into mediation. Texas was in the forefront in terms of institutionalizing mediation in the courts. And I'm going to insert myself into this picture at this point, because it's around that time that I left the law firm I was in, and the senior partner came in and said to me, "You're leaving in order to go to a meditation center?" He actually thought I was following his model because he did meditate every day, this senior partner. He's a really wonderful man. I explained to him at that point what mediation was. Fast forward a few years, he then became the chair of the board of Mediation Center in Minnesota, which I was the executive director of at that time. So, you know, kind of full circle. But also a couple of years after leaving the firm and going to Mediation Center, I found myself sitting back in a chair just marveling at how much progress we had made by the early 1990s. Because as a result of my organization and other organizations and individuals advocating for Minnesota's courts to institutionalize ADR in the way that Texas had already done, we had been successful. The legislature now had authorized Minnesota courts similarly to order parties into mediation and other dispute resolution processes. And we were training so many lawyers and judges and people from other professions to serve as mediators. The wave was cresting and we were surfing that wave. It was so exciting, felt so successful. And man, you look at all of the ways in which mediation has been institutionalized today. I started making a list. In the courts, what are the kinds of cases on the civil side that are mediated? All kinds of family cases, parental termination cases, all kinds of employment cases involving not just contractual issues, but also discrimination issues, probate issues, all kinds of personal injury and insurance-related issues. Contract disputes, all sorts, big and small, construction matters, medical malpractice, bankruptcy, foreclosure issues, large to small sorts of cases, class actions regularly being mediated. High profile cases like the Dominion case, regularly being mediated. Small claims cases, regularly being mediated. On the criminal side, do we have mediation there? Yeah, victim offender mediation absolutely is a part of the restorative justice picture for a lot of courts in our country. What about on the administrative side, leaving the courts and instead looking at administrative agencies? Absolutely. Special education, one of the areas in which mediation has a serious role. And many administrative agencies at the state and federal level have adopted mediation procedures and been involved in them. How about community mediation? Does that still exist? Here in Texas, we still have dispute resolution programs, and there are community mediation programs around the country, sometimes not as successful or as active as I think they wished they could be, often forming partnerships with courts in order to, or police in order to make more cases happen. What about other kinds of community? Are there religious communities that have institutionalized mediation to deal with disputes that occur within their communities? Absolutely, both in the family area and also in the business area. What about schools? Peer mediation happening in all kinds of schools around the country. Is mediation happening at universities? Oh yeah, including Texas A&M. Mediation's institutionalized here to deal with issues that often arise between roommates and even that arise within the classroom. What about institutional mediation? Different organizations besides universities. Hospitals regularly have incorporated mediation to deal with disputes. Employers, big corporate employers often have mediation programs that they anticipate their employees are going to be involved in. Big corporations Many of them that have inserted arbitration clauses now also have a mediation clause as part of that tiered dispute resolution process. Insurance policies often include that kind of a procedure. And then I think about employers that are not necessarily US domestic employers, but organizations like the World Bank or the International Monetary Fund that are dealing with employees from all over the world who come from all different sorts of legal traditions. They also have institutionalized their own mediation programs to deal with those. Okay, and even on the international political basis, haven't we really also been hearing about different nations trying to step in and mediate in the Middle East? Yeah, we have. So mediation, it's everywhere at this point. I think it's less likely I would have somebody mix up the words meditate and mediate. Still not impossible, I have to say. So I've just suggested that mediation is happening all over the place. But how much of it is actually happening? This is a little hobby horse of mine. Who knows? We really have no data in order to provide that information for us, which I have to say, I think is crazy. But also your picture, your sense of how much mediation is occurring really depends on your particular slice of it, what you personally experience. Because here in Texas even, I have had some people who have said, judges, for example, who have said to me, I send every case to mediation. Mediation is happening all the time. And I have others, lawyers or mediators, saying it's not happening much at all. Which is it? It depends on where you sit, what your own experience is. I can tell you though, and this does not count as empirical research, empiricists in the room or watching. I can tell you that 2 days ago, I did a Westlaw search. It was a very simple search. I searched for all the cases in the last 12 months that had included the word mediation in the judicial opinion that was posted on Westlaw. And you know what number I got? 3,000. That suggests there's quite a bit going on. What about what mediation is? I've used that word quite a few times. There's so many different models of mediation that exist now. We've got the facilitative or elicitive approach. We've got evaluative or directive approach. We've got the transformative approach. We've got the understanding-based approach. We've got the analytical approach. We've got the adaptive approach. We've got the therapeutic approach. We've even got something called binding mediation, where essentially mediator makes a proposal and you accept it, and then you're bound by it, which sounds to me, I have to say, a lot like arbitration, but you know. All right. And then what does mediation look like? What's its structure? Is it in person? Is it online? Is it text-based? Does it involve joint sessions? Does it involve caucus? Well, yes. Yes to all of the above. Who are the mediators? Lawyers, psychologists, authorities in different senses, people who are connected, neutrals. Wow. There's so much diversity within this word, mediation. Do we know that what's happening is good? Even if we know a lot of it's happening, do we know that what's happening is good? Well, I think it depends in part on how you define what's good. I have a feeling that's going to come up as part of today's sessions, which I'm really excited about. How much control over the outcomes should people have in order for the process to be good? That's what we used to call self-determination, right? I don't know. How much of a role do we want the parties to play? Really active role, more passive role? I don't know. Kind of varies. Is there so much diversity at this point that it's not really even possible to identify what mediation is? Some would actually say, yes, it is not really possible to identify what mediation is, but I have to say, thought about this and I thought, well, let's see, the word parent. Do we know what a parent is, even though practices in terms of parenting differ remarkably? Could we identify a teacher, even though there are lots of different ways to teach? Could we identify a boss, even though there are lots of different ways in which to be a boss? I hope by the end of today, we'll be able to say there still are some commonalities that characterize mediation. That there is a third party neutral, that neutral is helping the parties come to resolution. It is a resolution that is not going to be binding unless they agree that they want to be bound by it. It has to be voluntary. And then I come back to, even if we can say what mediation looks like, is it good? Let's say a couple more words in connection with this before I then turn it over to our panelists to examine this topic in greater detail. So when I first was introduced to mediation, I was enthralled by it. The idea that people really were having such difficulty being able to talk with each other, and that the law was kind of a dead end. They were never going to agree on how the law applied. That mediation and mediators could provide them with a different language, different way of speaking to each other, of understanding what each other really cared about, that whole idea of underlying interests. Enthralling. The idea of self-determination, that's American, right? The opportunity to investigate what were the possibilities, the opportunity to be creative, all so exciting. And when I mentioned sitting back in my chair and feeling like the wave was cresting, that's the future I saw. We were all going to be doing that kind of thing. Then I started reading some of the empirical research, and I saw that mediation was becoming more evaluative, more focused on the law. People weren't really doing so much talking. And also, despite the excitement of self-determination, there was also research that was coming out from Donna Shostowski later, indicating that all people really wanted was the ability to veto something. That was the extent of the control they wanted. So then I thought, well, maybe self-determination is not, maybe that's not the focus, or can't be the focus. Maybe instead it has to be on what does the process look like? Is it a process that is fair? And there's lots of interesting research and useful research on what makes for a procedurally fair process, one in which people have the opportunity to be heard, that they don't just want to know that they have spoken, but also that the person they're speaking with has heard what and tried to understand what they had to say. They're treated with respect, that they are going to be treated in an even-handed way, both in terms of the process and in terms of the application of norms. And what I hoped was that if they had a procedurally just process in mediation, that then too there might be the potential for self-determination and creativity and coming up with resolutions that people really supported. But I have to say that in subsequent years, I've become concerned about whether procedural justice is enough, or even whether you can count on something really being procedurally just. Can't you fake it? Really listening? Haven't you ever faked it? I have. And if you fake it, is it really a procedurally just process? Also, learned about research in which it's pretty clear that there are some people who, even if they are given the opportunity for voice, have come to realize that if they take that opportunity, it's actually going to come back to bite them. So it'd be better not to talk. And again, haven't you been in meetings, felt that same way? I have something that I think it could be important to say, but what's the point? Yeah. So can we really count on mediation as a procedurally just process producing something that's good? Well, I worry about that. And then relatively recently, Howard Gadlin and I co-edited a book, Evolution of a Field. And it profiles a number of different mediators, some of whom are mediators and dispute resolution experts, some of whom are in this room. And I was struck that some of the mediators who have been in the business for a really long time talked about how the nobility in mediation isn't necessarily self-determination. It isn't necessarily procedural justice. Instead, it's just the simple nobility of helping people bring conflict to an end. Period. And there is a simple nobility to that. Mediation is not the only process that does that. There's lots of other processes that bring a conflict to an end. What is it about mediation that makes it unique? So this picture, this an idea of two faces of mediation, it absolutely reflects where I am in terms of the mediation process. Where is its promise? Because it does, doesn't it? Doesn't it still have promise? And where are the areas of concern? Because there also are areas of concern. I want to thank my colleagues for, especially Michael Green, for helping to ultimately persuade me that we should have a symposium that's just on mediation. I want to thank Peter Riley for recently turning his attention from negotiation to mediation and looking at whether it's achieved his promise. He's going to be a moderator, but I look forward to his comments and perceptive questions along the way. Thanks as well to Cynthia Alcon, Guillermo Garcia Sanchez for their engagement with this symposium and all of our dispute resolution courses and programs throughout the year. I want to thank Kay Elliott with her husband and the first dean of this law school, Frank Elliott, who actually introduced mediation to the law school's curriculum. And I finally want to thank all of you, including our wonderful presenters. It's so exciting to have you here. All of you for being here today and all of you who are participating online. With that, I think what I am going to do now is call upon our first panel, the panel that has been titled Bullish on Mediation. Thank you very much.
So first of all, I just want to thank everyone. And of all the people that Nancy was highlighting and thanking, she didn't highlight or thank herself. And I think you can all see why we are so privileged to have Nancy leading our program. And we are all very grateful for all that you're doing. And so I wanted to make sure that we highlight you, and you can see what an amazing leader she is. And I'm standing just because I want to make sure we've got this set up. So I can see Jim on the laptop, but we can't see him on the screen just yet. So I'm hoping we're going to get that sorted in a minute. So that everyone can see Jim's smiling face. So it is a treat to be involved with this symposium for the whole day. And it's a particular treat to be moderating this panel with these three wonderful people who are, once again, want to say it's just a privilege for me to be moderating this panel. I'm not going to go into great detail about the amazing background and experience that our three speakers bring to this topic. Instead, you can look them up online. I think we've got their bios online. But instead, we're going to get right to it. I'm very grateful also that we have the technology so that Jim can join us virtually, since he can't join us in person right now. So thank you, Jim, and I'm going to just turn it over to you.
Thanks, Cynthia. Can you hear me okay?
Yeah, we can hear you fine.
Good. And I apologize for not being able to be there, and I'm particularly pleased and thankful that you are able to accommodate me in this way. So let me get started by saying that I am generally positive about the future of mediation, in large part because it's demonstrated its resiliency and ability not only to adjust but to thrive under difficult societal conditions. A prime example, of course, has been the ability of the mediation field to adjust to the consequences of the worldwide pandemic. As you know, our field turned to online dispute resolution as a means of adapting. Over the past 5 years, there indeed has been a paradigm shift in terms of the predominant format that we use for commercial, particularly for commercial or so-called high stakes mediations. We've shifted from in-person to online mediations, again, as the predominant mode. My son, David, is a lawyer here in Chicago. I'm up in Chicago right now, by the way, who, as part of his practice, represents parties in mediations. And I asked him how many online mediations he was engaged in prior to 2019. And he said, very few. And then I said, during 2023, how many mediations were you involved in? And he said, about 20. And I said, how many were in person? And he said, 1. So about 95% of David's mediations this past year have been online. Lest Nancy Welsh accused me of passing this conversation with my son off as empirical research, I'd like to spend the rest of my time focusing on the experiences of major mediation providers as reported at a recent conference. At the recent Mediation Institute of the ABA Dispute Resolution section, a panel of officials from the major providers, Matthew York from JAMS, Svetlana Gitman from AAA, Abby Hoffman from ICC, Mara Weinstein from FINRA, Mia Levy from CPR, Todd Drucker from the Miles Mediation Group, discussed how their organizations are doing at present, how they adjusted to the pandemic, and their ongoing initiatives. So, somewhat unsurprisingly, when they discussed mediation process norms in 2023, there was a strong consensus that virtual mediations had become the predominant mode. The FINRA representative explained that they changed their policies to make online mediation their default option after about 90% of their cases had become virtual. That is, mediations are automatically scheduled as virtual unless the parties ask for in-person mediation. She pointed out that when the parties ask for lists of mediators to choose from, they can give more mediators a chance now of being selected because online mediations allow them to compile lists by time zone rather than by a narrow geographic location. The CPR representative couldn't recall a single in-person mediation during 2023. And CPR had recently launched what she referred to as an integrated video conferencing system, which allows the parties to have access to the entire case file during the mediation. So documents can be pulled up and worked on together, and even DocuSign. She explained that all of this is integrated, so it's particularly helpful to have it in a virtual environment. The AAA representative was a bit more general. Quote, I think where parties are trying to save cost and time, get an earlier mediation setting, they're all on board for virtual. They actually expect it and expect the mediators to be available virtually. The only time I still see in person is what I call client control issues, where the parties feel like everyone has to be in the same room for a resolution to happen. So this paradigm shift to online mediations resulted in much greater attention being paid to cybersecurity. The CPR representative stressed that since they had launched a new integrated video conferencing system, quote, we have to have a secure place for their documents and document sharing and a secure means of communication. They all emphasize that they're spending a lot more time and expense on training their staff and neutrals on cybersecurity. They were particularly effusive in describing their fears over breaches of privacy and confidentiality through hacking. The JAMS representative was perhaps most effusive. And I quote, what's changed in a very short period of time is not the if, but is now the when. It's not if you are going to get attacked, it's when you are attacked. Each of these organizations would tell you that I think it happens all the time, nonstop. We're targets because of the type of materials and the substance that we handle. Bad actors are coming in from all different places at all angles. He said that the service providers are investing a lot of time and money in developing plans for addressing compliance and privacy issues. The AAA representative said that when they have cybersecurity, they even have cybersecurity boot camps in their offices so neutrals can come in and they can teach them. The FINRA representative said one way they're dealing with security concerns is they've disabled the Zoom recording function in its entirety, and they've disabled the chat function in the breakout rooms. So the shift to online mediation has apparently affected also the diversity efforts of the big providers. JAMS has a full-time DEI director. The AAA Foundation has diversity scholarships and a diverse student summit. So I'm positive about the future of mediation in part because of the way the field has responded to the pandemic by moving to mediations that are now often being conducted online. Since the pandemic, of course, online ODR has become widespread. I am concerned, however, that those of us who are not connected with the big mediation providers and thus can adopt a more objective view of the consequences of this paradigm shift are not paying sufficient attention to these changes. To be sure, some academic commentators have suggested that online mediation requires an adjustment of mediation standards and practice, particularly with regard to confidentiality. Susan Exon has argued that, quote, the biggest problem is that confidentiality and security in an online environment is beyond the sole responsibility of the mediator. And Noam Ebner counsels online mediators, quote, do not promise what you cannot keep. Be explicit about what you can promise and what you cannot. Refrain from promising, quote, we will all be keeping this secret. So I'm positive about the future, but we may have to be more diligent in developing procedures and practices that will ensure the integrity of the mediation process. Thank you.
Well, good morning.
Morning.
So I wanted just to highlight, this is of course a very important topic, very close to my heart. One of the areas I write in most frequently and teach in most frequently in mediation. And I wanted to say that in reading some of the articles back that were written in the 90s and 2000s about the future of mediation, one of the things that I think makes this question interesting is that one of the main predictions was that in the future, consumers would come directly to mediators. And that is not something that largely has happened. And I think that is one of the pieces of this question that is interesting, because that hasn't happened, at least not in the US and not any other place that I know of. There is this maybe feeling like when mediation hasn't been successful, that wave that Nancy talked about sort of crested and then crashed somewhere along the lines. But I am also bullish about mediation because mediation has grown, is being used, but often not necessarily in the ways that are obvious or maybe publicized as much. But I believe that there has been an upward trajectory of mediation. And so I have 5 reasons why I think mediation has a bright future. I do have concerns. Some of them Jim has raised, and others will talk about those concerns later in the afternoon. But here are my 5 reasons. First, there's an increased use of mediation in civil and business. And so again, as Nancy says, there's really a lack of data, especially in the US on this, but there's some indications that this is happening. So the Center for Effective Use of Dispute Resolution is a UK version of our CPR, and they do biannual surveys on the use of mediation. And that trajectory, if you go to that website and their surveys, is all up. Usually 10 or 15% each year of the use of mediation in the UK, Ireland and Britain. The UK Ministry of Justice just announced that all small claims, those are claims that are under £10,000, have to go to mediation before they go to any kind of adjudication. And that seems to be a precursor to the next phase of under £25,000 seems to be on the plate too. So we have these court systems, at least in the UK, doing it. Of course, the US court systems have been doing some version of that with different variety over the years. And then sort of building on what Jim had just said, the JAMS, which is one of the largest private providers of mediation services in the country, recently reported in, I think, the timeframe from 2020-21, a 30% increase in their workload, with most of their mediators seeing a sign of increased work. And so that, I think, purports that there's quite a lot happening in the mediation in the business and civil world. There's some, as also Nancy, this was a big news, right? To have a huge settlement. This, if you remember, Jerry Roscoe, who's a JAMS mediator, was basically called off on vacation days before the trial was supposed to happen and mediated a very highly publicized case. I think successfully. Certainly, I think Fox News got the better end of that deal. 2, increased use of special education disputes in California. This is something that Kelly is going to be talking about on this panel. But I just want to highlight something in California that's happening, is that in 2021, California put aside $100 million to promote the conflict resolution of special education disputes, and mediation is the primary beneficiary of that, because that is the primary way that special education disputes get resolved in California, at least. And so I think these are things that you don't really hear so much about mediation, but are happening, and are happening at different places all across the country and really across the world. The third one, again, is this is sort of subterranean, the expansion of the agricultural federal mediation program. This was something that happened in 1987. It was a small program funded by the federal government, often supplemented and run by the states. And now each year it has grown in terms of its spread. There's almost 40 programs. There 40 states have these programs. It was originally designed to prevent the financial catastrophes for small farms, but now it's spread to organic disputes, lease disputes, neighboring farm disputes. And so again, you can have the article that this is based on, and it's just this, again, trajectory of increased use and increased value. The fourth one is what Jim has been talking about, which is the post-pandemic increase of online mediation. And this has, again, to add to what Jim has just said, many mediators have gone, again, exclusively online. As he just talked about, the major providers seem to have gone almost exclusively to online mediation. But one of the things I'll add is that the surveys so far have shown that these mediations are just as successful or more successful, both in terms of settlement and in customer satisfaction. Now, this is early days. I just want to highlight, there's only been a couple of formal empirical studies on this. And there's been some informal reporting of mediators who are doing a lot of it, especially from the major providers. But I think this is something to watch because I think it is exciting. The idea that you have more availability of mediators. It can be more cost effective, certainly, if they have legal representation. Just a couple of the studies that I've seen recently, the EEOC have published 2 surveys of their program that they had a mediation program for many, many years. And of course, during the pandemic, like most mediation programs, they had to go online. But they also did some really great surveys showing that their settlement rates were as good or better. And more importantly, the satisfaction by both the plaintiff and the defendant in these cases, or the disputants in these cases, were highly satisfied. 90% would recommend using it again or would use it again. And more than 80% were extremely satisfied with the process. So I think that really portends a lot of value for mediation in the future in this online realm. So again, I think there's a lot of open questions about it, some of the confidentiality concerns and others. As a mediator myself, I've done a fair number now of online mediations, but I will just say that, sorry, is Colin Rule here yet? I'm not sure he's here yet. I still want to, there's some mediations say, God, I don't know if that could have settled if we weren't all in the room, but I'm going to sort of keep my mind open to the research as it comes around. The last one is sort of a bigger deal, which is the Singapore Convention on the Enforcement of Mediated Agreements in foreign disputes and international disputes. So this is, of course, has been in the news recently in the last few years. But I think this is a game changer for mediation, international mediation. So if you know, the United Nations Convention on International Settlement Agreements resulting from mediation renders international dispute resolution easier by making those mediated agreements enforceable in signatory states. And so if you remember, the New York Convention, which was passed in 1957, is the equivalent of this for arbitrated agreements. And many people believe that that ability fueled international arbitration to what it is today. The idea that you can take these agreements, have these international agreements, and then, and again, I think there's almost 180 countries that are signed on to the New York Convention. You can now have those agreements enforced. And so I predict that the future of international mediation will go the same way. That as companies and organizations and individuals believe that they can enforce those mediated agreements where the assets are, right, whether they're in the US or UK or one of the other signatory states, then they're going to be much more inclined to put mediation clauses in their contracts or ADR escalation clauses. So for those reasons, I'm very bullish on mediation. I think there are concerns, and a lot of the concerns are things that the other panels will talk about, most specifically, how is mediation conducted? And what do we call mediation? Those are some of the questions that Nancy raised. So that's my sense of the future. Thanks so much.
Good morning, everybody. I'm Kelly Burleson, and I teach at the University of Arkansas Little Rock Bowen School of Law. That's maybe been the full title, but that's what we'll go with today. I'm going to talk a little bit about the Special Education Mediation Project that we run that is statewide. And then talk about why, because of this project, I'm bullish on mediation, and I think that it's a good thing. I wanted to give you some background. I know we have some people in here that have that know a little bit about special education mediation, including our hostess, who has written an article on it that was key in thinking about how we set up our program. We're the only law school in the country that has the statewide contract to do special education mediation, and our students work on these cases, but they are not the mediators. We have trained professional mediators who are certified in Arkansas and then go through another 16 hours of training to do the mediation. But the students actually do the background work. And so they talk to the parents and they talk to the school and they decide, help the parties decide whether they should have an FIEP or a mediation. And we'll talk about what those look like. So this is about what's going on in schools. And I don't know if you know this, Michael was talking about the increase in the money that California spent on that. And the reason that California spent $100 million on this, I would assume, is because it cost them triple or quadruple or even more than that to provide the services to the children and to take care of the children who aren't in these classes early enough. So they saw it as a money-saving opportunity to spend the money on mediation and to get these children going. And one of the things that happened during the pandemic was it hit all of us hard. We were having a conversation last night about how all students from elementary school through college through law school were impacted by the pandemic, but it especially hit hard the special education students who are not always comfortable in classrooms, much less behind screens in their home, and whose parents didn't have the resources to provide for them and help them with their studies, with their education, with anything that they were going through while they were also working. And so right now what we're seeing is a huge push to have some reimbursement for what didn't happen for those students during that time. So two of the projects that we do, and I'm thrilled that my project started this in Arkansas, and instead of being known as 49th or 50th in something, we were actually first in something, which was starting these facilitated IEP events. It's not mediation, it's facilitation. That's really important in Arkansas, and I'll talk about why it's important in other places. But the facilitated IEPs are specifically not about what's going on between teachers and students and whether an IEP is followed. But facilitating the IEP is actually creating the IEP for the first time or revising it on a yearly basis, and the focus is on the document itself. So many of the cases we're seeing these days do both. They have a mediation and they have a facilitation, but the facilitation is important because the things that we discuss, the changes that are made go into the document. And the document, we all in this field know about legalese. A lot of the IEPs, provide for a lot of acronyms that even the teachers don't always understand, much less the parents. And so starting off by creating a document that works for the teachers and the parents, we've found creates many more bonds between the parents and the schools. So mediations, we're talking about behavior issues. We're not just talking about child behavior issues. We're talking about how the teachers are treating the children, what's going on in all of the pieces that surround. Is the IEP being followed? What does following the IEP mean to the parents, to the school administrators, to the paraprofessionals, all of those parties? And so that's important, but it doesn't necessarily change the IEP because there isn't necessarily an IEP team there. Okay, and you need an IEP team in the room, which is 5 professionals that have different roles to change an IEP or to create one in the first place. So we make sure if we're doing an FIEP that the team is there. If we're doing a mediation, the mediation might be between 1 or 2 teachers and the parent. It might be between the parent and the vice principal. It might be between members of a school, because there can be differences about what an occupational therapist and a physical therapist think a child needs versus what the principal needs. So in the FIP meetings, we talk about all of these issues, and the last one, see, I'm using an acronym, and I just said we shouldn't. Behavioral intervention plan. So usually in mediation, the parents and the schools have gotten to know each other, and it's not a great relationship, right? If it was a great relationship, how do I know it's not a great relationship? We wouldn't be there, right? If they could talk to each other, they wouldn't need us. Required by law, the IDEA was one of the first, as Nancy alluded to earlier, areas where mediation must be offered by states before and after parents have requested a due process hearing, which is one of the administrative remedies that parents have when they have issues with what's going on with the school. So whether their child is in special ed or perhaps was denied the ability to go into special ed, they can request a mediation or several other processes. So the difference in the protocols, which I just talked about, is that there are clear requirements for the FIEP, and there are also clear requirements in Arkansas because we have a very strong mediation standard about the confidentiality of it, the work product that comes out of it, all of those other pieces. We have the same people who mediate and facilitate, but we have very different processes because in every facilitation, there's an agenda, and the agenda is created because the parents bring information to our students, the school brings information to our students ask more questions, They request maybe the previous IEP or other testing that's gone on, and they create an agenda. A lot of times the school will say, here's the agenda for the meeting. And we get to say, well, that's great. We'll be sure to include this information, but we're also getting information from the parents. So this isn't the meeting agenda. This is part of the meeting agenda, right? So these are different processes that parents can use, and I'm going to jump right to this one because I don't have a ton of time, and talk about Cadre, which is a great resource. If anybody out there wants more information on anything having to do with dispute resolution processes in school, Cadre is your source. And they're out in Oregon, and they talk about how the different dispute resolution processes go along, and who is making the decisions. And mediation is one of the places where you have that third party neutral. Okay, and they are neutral. We're not employed by the school. We're not employed by the parents. Frequently parents come and they think because they're contacting our program and they've been referred by doctors or therapists or the people that we can be a mentor to them. We can't be, but there are things set up for them to find mentors. We're very clear. It's one of the first lessons the students have to learn, to be very clear to set boundaries, because we're neutrals, we're not mentors. These are the different types of processes that parents can get involved in when they have issues with their students in school. And I'm also not going to go through these, but I have these resources if people want them. Our part of it, which is ASEMP, is the Arkansas Special Education Mediation Program, or the facilitated IEPs. Anyone can request them. And interestingly, one of the areas that we've gotten more involved in, which is another area I'm involved in, is dependency neglect. We're having more requests from caseworkers and from foster parents, which is great to have that overlap with those children, because frequently they're left behind as well with these processes. So why might parents or schools request mediation or facilitation? If there is some kind of relationship and they want to help it further it can preserve the relationship. It can also create a relationship. And when we talk about being bullish on mediation, one of the things that mediation can do is help that communication, just like any kind of mediation. But in these schools, a lot of the times you have the classic people talking over each other and waiting for their turn to talk and not really communicating. And parents thinking that schools don't want to provide services for their children. And a lot of times parents and schools have a very different experience with the same child, right? So what they don't realize is that the child, whatever boundaries they have at school, they have different sets of boundaries at home. And maybe one is better than the other for the child. They react differently. Some kids go home and just dissolve and are horrible. And the parent will call the school and say, what did you do to my kid today? And the school will say, he had a great day at school. Well, he couldn't have had a great day because he's doing really poorly now, or vice versa. The school will call the parent and say, your child did this and this and this and this. What's going on? And the parent will say, they're fine at home. I don't know what's going on. It must be you. Right? And so these mediations are really wonderful for that, because they create that sense of community and they help people to figure out what's working and not working for students. We can talk about anything in mediation. It doesn't have to be in the IEP. Okay, if we're doing a facilitated IEP, those conversations are a little bit more limited. Sometimes they delve into mediation territory. And the one thing that I've told all of the mediators and the facilitators is that it has to go in the FIEP. If you can figure out a place for it in the IEP, that's great, because the concern is we create memorandums of understanding in our mediations. But if we did that in an IEP, it could get lost, because the memorandum of understanding is something that's going on between the teachers, the administrators, and the parents now. The IEP is going to travel with that student, hopefully, and they're going to have that document. So whatever we can put in the IEP, if we have an IEP team there, is good. In Arkansas, there's another issue, which we're going to change finally, is Arkansas and Pennsylvania, and I don't know if there's other states, don't allow lawyers in mediation. Okay, and they do this for a variety of reasons. One of the reasons is many of the lawyers in the special education field are very litigious, are very aggressive, and some of them have reasons to be when schools are not providing things to students, but they don't change modes easily. And what the State Department of Education saw was that they were taking advantage of mediation to get their attorney's fees and were more interested, this was their perception, in negotiating attorney's fees than helping children get what they needed. So they're not allowed in mediation. So we struggled with this because some parents are focused on having the lawyers represent them, cannot represent themselves. So in facilitation, there's no rule against it. So we let parents know when they're requesting, well, this is an FIEP, this is a mediation. If you want your lawyers, they can come to an FIEP, they can't come to a mediation, right? But we're getting that changed, which is wonderful. They're gonna start allowing lawyers in mediation, which I think will be helpful as resources because it will keep people straight, and it will also keep my mediators from being frustrated that schools don't understand the law or the parent doesn't understand the law and there's no one there to help them with it, right? So why it works. So one of the research that has been done, and I've got a lot of anecdotal for all the years I've run this program, but research has shown that parent engagement is important. And what we know is if they feel a part of what's going on, they engage more, right? If they feel like they're not being heard or listened to, they don't engage. And it helps student engagement and it lowers at-risk behaviors. Now, one of the things we have found, and this is of course not true all the time, but a lot of the parents that we work with have some of the same issues that their students have. And that was never brought up when they were in school and it was never focused on and it wasn't an issue for them. They may have taken, for example, ADHD or other things and made it help them, work with it, found skills for it. But they have some issues getting together with the school or listening to what the school has to say. And so we now in our forum say, are there any accommodations that the parents need for these meetings as well as the students or the school? So with that being said, I've got cost analysis, I've got a bunch of other things. But mediation, one of the things is parents don't have to choose between mediation and going through due process. They can do both. So it's not an either or. They can try to work things out, and if they don't, they can go to due process. What we found is that it actually is split 50-40 with the school and the parent requesting it, and then some of ours come right from the Department of Education. That they've heard from both the school and the parent that they're frustrated, but they can't get either of them to ask. These mediations are absolutely voluntary. We do not do them unless both sides are willing to do them. And that's important too. So parents aren't dragged into these mediations and the schools aren't either. So I think that that's important. Like I said, the IDE has had this for a long time, and they want, one of the issues with mediation that works as opposed to just resolution meetings or meetings between the schools and the parents is that there are requirements for people to be there and stay. One of the things we saw early on before we set some boundaries and some ground rules was that teachers would come in and out of the meetings. And that's just another sign for the parents that they're not being respected. It's another sign that their child isn't as important. So we can set these ground rules, which is harder on a school that's doing it themselves. How are students involved? Our students involved in this? They do logistics, they do support, they're empathy, they're a friendly ear, and they're not advocates. And it's important for the parents to have someone helping them. If a lot of our parents don't have attorneys or don't have the resources to do attorneys. And so the students can work with them, but they also are an ear for our special ed teachers and our other people to talk about sort of what they're doing and how it works and what the parent might not be understanding or that they can't get the child to engage in. And so they do come in feeling a little bit heard before they even sit down with the mediator. And the mediator, because it's only a limited amount of time, has some background in what's going on with both parties because the students are doing this. So 85% of all special education mediations reach an agreement. In Arkansas, we're a little bit higher than that, which is great. Most of our cases settle before they go to due process, but due process hearings, even the lead up to them, cost the state a lot of money, and mediation is cheaper, going back to all of the dispute resolution that Michael was talking about. So why am I excited about mediation? Why do I think it works? I presented 2 years ago at the Texas A&M Symposium on the concerns I had about going online, because we all went online with special ed during the pandemic. I think it can help and it can hurt. But what I do know from online is that we are able to do more and have more time with it in different parts of the state where we don't necessarily have mediators and it's harder to schedule things. Parents like to go online to do it. we can have people communicate with each other and look at each other online if they're participating in that way. What I know doesn't work is hybrid. I just had this conversation last night with one of my students because the school wants to do the whole thing. They're going to be in one room and the parent is going to be online. And so we asked the parent, we said, this is hard. Why do you want to be online? And she said, I don't want to be online. I'm not allowed on campus. And the school said, well, we can't change the rule just for this. And I said, this is not going to work. We are not going to do this where the parent is off and is online and everyone else is in person. And so we've got alternatives. You can have it at the law school, you can have it at off campus, or you can make an exception for this time and we can set ground rules. But that's a relationship that is frayed so much that even though they want to mediate, they don't want her to be there. So online is good, hybrid is bad. The future looks good. And I'll tell you, my students have a lot to say after these meetings. They're very invested in it. But one of the things that we've talked about is, do we make a difference? So 2 of the mediations that my students went in on, there were some contentious things, but they went in, the teachers were nice to the parents were nice to the teachers. We came up with an agreement. So the student came back and I thought asked a very thoughtful question in her journal, which was, are we even necessary? And I think it's a great question. So we talked about it in class and I said, are we necessary? Maybe not. And wouldn't that be a good thing? But would they have been as friendly? Would they have had the information to share? Would they have communicated in that way if a stranger wasn't there? I don't know about your family, but growing up, my family always acted a little bit better at the dinner table when there was a stranger there than when it was just family, right? And so we've got some very contentious cases that I know mediation plays an important role because we work with the parties to get them to work together, right? We have some other cases that are not as contentious, but maybe people just weren't stepping up because light hadn't been shown on what they were doing or how it was impacting each other, how it was impacting the parents, what was being said. The parent who says, I'm supposed to get a report every day after school from my child's teacher. Why am I not getting it? Well, let's talk about what's going on in that teacher's day, the students they have, who set it up? Who was it, the teacher that said, I'll write a report every day? Or was it an administrator who said the teacher will write a report every day? And talk about what those mean. And that's why I do think mediation is moving forward. And it is a huge help in these cases. It's creating relationships. One of the pieces that I talk about, because I handle family cases as well, is do we all need to be together? Do we need to do the caucus model? One of the things we found is special education mediation. Usually everybody's in the same room. We want them to have that relationship. Just like we want them to work together in that meeting, we're trying to set them up to work together without us in the future. These are people who have an ongoing relationship. We don't do special education mediation just to focus on the past and set something up where they're not working together. Some of these students are going to be in these schools for 2 more years, 3 more years, 8 more years. They need to learn to work together, hopefully without us. So we're setting them up for the future. We want them in the same room. Caucus is a tool to reality check, just as in every other mediation. It can be an important tool to check with the parents, see how they're feeling, check with the school, check with individual teachers, but it's a tool, it's not the model. And with family, one of the things we're seeing is there's a difference between parents who need to work together in the future and parents who don't. And people who aren't parents, and they don't have an ongoing relationship. But this is a place where there are ongoing relationships. Something happened, whether it was misinformation, disinformation, a denial of services, confusion about what the child wants. We had a case where the parent came in and said, my child's not getting any services. This is ridiculous. They've been in services for 3 years. How can they not be getting any services? And we're like, well, of course they should be getting services. And we called the school, the student called the school, and the school said, well, they're a transfer from another school and no one gave us any of this information. Parent just thought the information flowed with the child. And so the school didn't have any information. And so that's a simple fix. Some of them are more complicated, but the fact that we're getting involved and these students, I love the fact that the students are involved and are learning how to talk to people, how to talk to clients, how to do other things, makes me happy about what they're doing. So I'm very excited about the future of mediation. Thank you.
Okay, so hopefully we will get Jim back on because we've got time for questions, which is wonderful. And so what I think I'll do is I'll start in the room and then we'll see if we've got any questions from our Zoom providers.
Yeah, at this point, I'm not aware of any.
Okay. Okay, so do we have questions questions from the room? Yes, please.
For Kelly, have you seen any impact from the Arkansas Learns Act and any of the restrictions that that puts in place on your facilitations or mediations?
I'm gonna, I'd be happy to talk to you about that off camera.
Okay.
But yes, and not positive ones. It's hard because of the different regulations that are for people that don't know, the Learns Act is now giving money to families to take their kids to private schools. And what we're seeing is a lot of the private schools, they don't have the same requirements for special ed that public schools do. They do have something similar to an IEP, which is an ISP. But they don't know the rules and the regs very much, and we're seeing more students expelled without behavioral intervention plans, without manifest determination reviews. And we're also seeing schools that after they get money for the student for that year, they then kick them out. So that's what I'm gonna say about that for now.
Other questions? Yes.
This is also for Kelly, and you can punt this to later if you want, but you've got a context that is one in which your mediators have information about the law.
Yep.
And you've got a lot of unrepresented parties.
Yep.
And I guess I'm just wondering about how you and yours have experienced that tension that at least many in the mediation community talk about neutrality and partiality, insert your thesaurus word here, and the legal knowledge that is important for them to have. I'm just wondering if that's looked any different in the context that you talked about today.
Yeah, it is hard in all of the cases at family, dependency, neglect, special ed, we are seeing more and more self-representing parties. And I think that there is this line that I discuss with my students and all of my mediators in my various programs about legal information versus legal analysis. And that's a really hard line, right? But the benefit and the reason we fought to have lawyers in these meetings is even if I just have a school lawyer, it's someone who can explain the law. And the mediator then can work off of that, even if the family isn't represented. But if I don't have any lawyers, it's hard. It's hard, especially where a school doesn't understand the law. And the mediator's like, I don't know, what would you, Kelly, what would you have done? And I'm like, it is a very hard piece. When a school says, there's a difference between a doctor's diagnosis and what a school has to provide. The school has to provide a fair and appropriate education. And so I use this example all the time of a doctor who in dentist development centers at the University of Arkansas Medical Science, it's a great program. And they want everything for the kids that need it. So they will diagnose a child with autism and will say that they, or just say they have some needs. And they will say this child needs 12 hours of occupational therapy a week. This child needs 6 hours of speech therapy. This child needs this and this. And the parents take this diagnosis to the school and say, look here, my child gets 12 hours of occupational therapy a week. And in this similar case that I'm talking about, that I've changed the facts a little bit, the school said, we have an occupational therapist here for our 350 students for 16 hours a week. They cannot see your child for 12 hours, that it is not going to happen. And the parent took them and tried to process this, and it's not going to happen. And so it's difficult, but I think that it is one of the biggest issues about mediation is, and I know I'm still on tape, but I can say this, which is we turn around sometimes and we go, when we stop getting money from the state to be neutral, we're going to sue a whole bunch of people. We're going to represent these parents or these schools or vice versa, but it is a fine line. I don't know that I answered your question. It is a fine line. I find that the information that we can present, and we have books for people and we can send them to websites. But the other thing is that there's a lot of misinformation on the websites. The people that do help the most and can also be problematic are the parent mentors. So the state has to, under Aggie as well, have parent mentors that are available. There's a handful of them across the state. And some of them are incredibly well-trained and understand the law and the policy and have children that have been through this or are educated in these issues, and they can really work with the parent and the school. We also have parent mentors that had a child that went through the system. They're not that well-trained, but they read up on everything for their child, and everything that their child didn't get, they want for this family. And they can be a roadblock in the process, and they're not formally educated. I'm dealing with a problematic parent mentor right now from Houston, who's in this program in She was hired by these parents. I'm sure she's getting a lot of money. But she has said multiple times to my mediator, who said to me, can I just say to her, then go back to Texas? Because she keeps saying, that's not how we do things in Texas. I think you should do it this way. That's not how you do things in Texas. That's not how this works. I've done hundreds of these cases, and that's not how we do this. And she has a very kind of litigation mindset, even in mediation, that we haven't been able. She wants to go to due process. Parents don't, who are her clients, because mom is an employee of the district. And so we've got a conflict. And so just talking to the mediator about this, where she's going to caucus with them so they can get on the same page about their goals, because they seem different. The other thing that I didn't get a chance to talk about, and we can talk about the future of mediation a little bit with some other things, is AI. So AI is becoming a part of our special education mediations because people are using it to draft goals in an IEP, which is really interesting because they can be neutral goals that the parties wouldn't think about, but it's coming from and we can have a further discussion about this, neutral source, where they put in what the student is working on, and the AI provides some goals and defines them in ways that people can understand them, which aren't always in the IEP. So I think this is a positive use of IEP. It's instant in the mediation. The parties can see it and discuss what's going on, as opposed to having a lot of IEPs. The plan itself will come in with the school having written everything out and the parent having to object to that. And instead, we're seeing some drafting of them in the mediation, which is what it looked like, but it goes quickly because AI is doing it. Long answer, short question.
So I do have a follow-up question, Kelly, but I think I'll start with the question that I actually have for Michael and Jim. Since you seem bullish on mediation, and I think one of the thoughts about people who are bullish on mediation, that they tend to be the people who are the insiders who do it. What do you think about how the general public views mediation, and in particular, like media representations and things of that nature? I always go back to the Wedding Crashers scene of how mediators are presented in a movie. We're the positive representations of mediation that are in the public sector that are outside of our realm.
You want to take that first, Jim?
Okay. Who was that asking the question?
That was Michael Green.
Nobody.
Michael, okay. Thanks, Michael. Yeah, for a long time, I've been concerned about the general perception of mediation by the general public. And I don't think things have changed very much. I don't think the general public has a greater sense of mediation and its utility than they did 20 years ago. And I'm not sure why that is. I know when I was in Florida, Florida had many extensive mediation programs early on. There were attempts to sort of get a better sense of its impact on the general public. And Michael may have some more insight into this than I do, but I don't know why mediation hasn't become a household word. Maybe that's the best way to put it.
So I agree with Jim. I don't think things have changed. As I mentioned before, most of the public doesn't come directly to us. Mediators get their work through other lawyers, other professionals, judges, or mediation systems. And my suspicion, my theory of why that is because we don't have the imprimatur of a license or of a meaningful certification. So if for those of you who don't know or not mediators, to be a mediator in most jurisdictions, be core connected, you need only 40 hours of training and maybe have to do a couple of volunteer mediations. That's it. And this is part of the problem with the variety of mediators out there and the quality of mediations. And so this is something Art has written about in terms of licensure, which maybe we'll talk about later. But I'm a big fan of having much more state regulation. And I'm not a big fan of state regulation to begin with. But if we want public buy-in, we can't just have mediators go to a seminar for a week and then say, I'm a mediator. And in many jurisdictions, you don't even need to do that, right? Unless you're court connected. So I think we're really a victim of the fact that a lot of people like it this way because they came up without training or little training. As we know, a very few percentage of the people have a vast majority of the mediations. And so just the status quo helps a lot of the people in this market, which is why when licensure gets talked about, there is a fair amount of opposition to it. But I believe that if we want public buy-in, we're going to have to be better trained and have some kind of quality control, which has been done in Australia and other countries. And if we don't have that, who do we have to blame but our own profession to say, why should you come? That's why you go to a lawyer, because they have all this training and they have all this authority behind them. We have none of that, which I think is a big part of the problem.
Can I answer that one, Mike? Oh, go ahead. Do you
No,
want
I
to
was just gonna call the next person.
Well, he had another question. I want to answer this one though. There was a television show probably 10 years ago, maybe, that had a mediator on it, like she was the star of the show. And I couldn't tell if it was written by someone who had never seen a mediation or a mediator that lived in a fantasy world where they could go and investigate everything and find everything out, because she would meet with people and then she'd be like, I think they're lying. And she would go and do all the background work to see, and then she would do, eventually people got to settlements, but I was like, this is someone's dream world. There are not good media representations. We have Judge Judy, we have other things. It would be really interesting to see if you could set up something like that where people talk to each other, but so much of this is private that people don't want to talk about it. And I don't know that you can show the magic that happens in some of these mediation rooms, whether it's online or in person, and what makes them work.
So I'm gonna go to Lisa before I give Michael a follow-up, just so we spread the joy
Fair,
around the room.
fair.
So Lisa, please.
All right, I'm changing the subject back to Michael. I don't know how many people in the room know Ron Kelly in California, who's one of the leading advocates and shapers of the Uniform Mediation Act in the United States. And I want he and my husband, by the way, is on Cadre's board, so.
Well, of course he is.
But I get these emails because he and Ron Kelly are like besties from a long time ago. And they get forwarded to me. And so Ron's written about the Singapore Convention. And he's identified 3 serious problems and conflicts between the Uniform Mediation Act and the Singapore Convention, specifically having to do with confidentiality, the neutrality of mediators, and voluntary uncoerced settlement. And I didn't know whether these are problems you're conscious or aware of or are thinking about, and whether you'd like to address those problems.
No, I don't have a lot of insight into the differences between the two.
Well, I can read
acts.
you what these.
Yeah. Yeah.
So the Uniform Mediation Act talks about mediation as a confidential and informal process in which a neutral intermediary helps 2 or more parties negotiate a voluntary settlement, right? Well, under the question of confidentiality, the Singapore Code allows courts to compel the production of any necessary document, not just to prove there was mediation, but to verify that the requirements of the convention have been complied with. It was decided not to limit this to the documents needed to prove that a settlement agreement resulted from mediation, which means that they can, people are allowed to make claims of misrepresentation during the mediation, which means they can compel disclosure of everything, basically.
Okay.
According to Ron, and Ron is someone I deeply respect. Second, impartiality and neutrality. It turns out that there is no requirement in the definition of mediation in the Singapore Convention that the third party assisting the neutrals, the dispute must be neutral. So that's real interesting. I
Yeah.
don't think I need to say more about that. And then the third thing he points out is the convention lacks protections against the third party coercing a settlement by threatening to make damaging reports to a court, a practice prohibited by the Uniform Mediation Act. And then what's going to happen is this international treaty is going to preempt state law. So I just wonder.
Yeah, there's a lot you're saying there, and I can't comment on all of it. I will say this. I still think the agreement, the Singapore Convention is a good thing. I don't have the insight that Ron has had comparing the Uniform Mediation Act to the convention. But the other thing I'll say is that there was a lot, the convention took decades to get passed. And what passes as mediations and mediators in different countries is different than here. And so other countries are much more comfortable with people who are not neutral in the same way we feel are neutral. And so to have a international agreement passed, I think we have to be open to cultural differerences and making the convention broader than maybe we are comfortable with. And so I understand that, and again, part of the restriction is that they enforce only mediated agreements, not settlements, right? So they have to prove that this is the agreement was a product of a mediation. And so again, I'm not saying there aren't problems with the convention, but I think on balance, what this means is that corporations and organizations that do a lot of mediations or have a lot of disputes are now more comfortable in the same way that they used to have arbitration agreements to put mediation clauses in and reach mediated agreements. I think, again, there could be lots of problems that still need to be worked out. It's a very young convention, but my sense is that it's going to increase it and then maybe highlight some of the problems that Ron has identified.
Thank you.
So as a moderator, I wanted to ask one question, then I'm going to go to Nancy. But one of the things, because this panel, we're focusing on the positives, the bullish on mediation. And one of the things that each of you mentioned was online mediation. And with the understanding that, you know, there are things to be said that are negative, but you were all focusing on the positive in a variety of ways in your discussions of it. And one of the themes that seemed to be coming out is that I don't know if it increased access to mediation or increases the ease of mediation. And I'm wondering if you can comment on it. Is it really having this online option? Do you think that this is increasing the numbers of people and the varieties of disputes that are able to come into mediation as compared to the before times when everything was mostly happening in person? And Jim, maybe I'll start with you because you had this overview picture of it, and then I'll go to the rest of our panelists.
That's a great question, Cynthia. One of the things that we don't spend enough time on is the access to justice claim that we in the mediation field have made over the years. You know, that mediation, the increased use of mediation will enhance access to justice. And it sort of relates to your question about whether there's greater access in this way. I think potentially there is, but it needs to be worked out. I think there, you know, to borrow a page from Nancy Welsh's book, there's precious little empirical research going on. And we really need to be looking much more closely at how at these questions in empirical studies. I guess that's the best way I'd put it. Can I add one little footnote to Lisa's question about the Singapore Convention? I think Ron Kelly's concerns are a bit overblown. I'm a friend of Ron's. I'm familiar with his concerns, and they're a little late in coming. The convention has been signed by over 100 countries, including the United States, and I'm hoping that the Senate of the United States can be convinced to ratify it. I don't think we can stop that process now by attending to Ron's concerns. I think, as Michael pointed out, on balance, it's a good thing. I'm sorry, I just need to have my say.
Yeah, so maybe Kelly can pick up with the question that I asked.
Okay.
Yeah.
So I think I find huge benefits in it. I find huge benefits in it for our parents that can come to a meeting while they're at work and take an hour and they don't have to drive somewhere and come in. I find benefits in it because one of the things in the dependency neglect mediations that I do, everybody can see each other and it's a little Brady Bunch, but putting names below people like you would do in a room, but people, they can make eye contact with people and they can see them. It also can lead to some disturbing other things that people who are on camera and don't realize they're on camera do, but that's another story we can talk about at drinks. The positives, I think that you've identified an important difference though. There's access and there's ease, right? So access to it is positive when people can do it, but we have bandwidth problems in rural Arkansas and we have issues where it's not a clear connection and it's harder and people, people that are on their phones, they're like, yes, I can do this. I can do it on my phone. Well, how many of you thought you were going to be on a computer and went to a phone to connect to something because you had to? And how much harder is that? Because you've got to, I went through half a meeting and someone said, well, I don't know who's here. And I said, well, can you see them? And she said, no. And I said, well, do you know how to scroll on the phone? Nobody had ever swiped on the phone. No one had ever taught them how to do that, to see everybody. And so I think when we talk about access, even if you have the ability to connect, what kind of instrument are you connecting on? And so then the ease, I think for some people who do well in person, they do well online too. And that works for them. And we see that in our students, right? For other people, they like it more online because they don't feel like they're on the spot. So one of the parents that talked to me, and we try to balance this, but we can have up to 9 or 10, even 12 people from a school if we've got the IEP team, and then we have the Gen Ed teachers, and we have the special ed teachers, and then we've got a parent and maybe a mentor, maybe 2 parents, maybe someone else. That's a huge imbalance. That imbalance doesn't seem as large online, is what I've been told, right? When we do our surveys. And they said it felt more balanced. And I thought that was a really interesting takeaway, that they can see everybody, but it's not so much one side of the table versus the other. And so there's some interesting pieces there, but I would love anybody. We need to get some researchers because I really, really need research on special ed mediation, on these FIEPs, and what are the down the line, how are these students doing? And is there more success based on these mutual IEPs?
My sense clearly from the survey so far, the ease is much better with the online. In terms of accessibility, I think there's less data, but for example, accessibility can be in the form of, there's some people whose lifestyle, they have children at home, they can't actually leave the house to go for 3 hours to a mediation, but they can do it from home. And so I happen to know anecdotally anyway from some of my friends who do family mediations online, is that's been a huge thing, that people who are in a position where, they have to take care of younger children can engage in a mediation from their home. And that could be a little frantic, right, with kids and pets and everything else going on, but they can do it. And I think one of the things Kelly said earlier was that the online mediation helped her to serve rural areas or other areas that where they really didn't have mediators close by. And I think that is something that we have to learn more about. So my sense is that we're going to see that the accessibility is going to broaden with online mediation, but yet, of course, the data is not quite there yet.
And I think Nancy had a question and we're gonna close it. We've got like 3 minutes, right? So
let me, quick comment from someone watching online. So regarding the Singapore Convention, I know that Ellen Deason, I think was the reporter in connection with the Ellen Deason with the Uniform Law Convention, and is online. She has indicated there's no contradiction between the Singapore Convention and the Uniform Mediation Act. And I have to say the fact that we've had the amount of discussion that we've just had on this suggests there would be real value in all of us learning a lot more about what the Singapore Convention provides for. Okay, now my questions. So, as Kelly, as you described the program that you run, I could see all of these different ways in which mediation is making a difference for the parties involved. Allowing for direct communication, allowing for better preparation, allowing for joint development of the agenda, allowing for improvements in the relationship, allowing for a different kind of outcome. That all seems really consistent.
I'm waiting for the but.
Yeah, okay, all right. Yeah, all right.
However.
Actually, I don't think I have a but in connection with what you described as this particular application of mediation.
Mhm.
My question is really, I'm turning now to Michael and to Jim, because I feel like in part, the idea that we should be bullish on mediation has to do with the fact that so many courts, so many countries, so many agencies have decided to expand their use of mediation. And the question I think I have for you is, why do you think that is? It's kind of, if mediation wasn't good, why would so many be adopting it? And so what do you think the reason is for not individuals to come to us with, but what do you think the reason is for so many institutions to be institutionalizing?
Money. They save money. And that's, I think, is a driving force. I mean, that's a simple answer and we could be more nuanced about it. But I think ultimately, for example, California's push of the $100 million for special ed mediation was because, in part, right? Because when in California under the law, if a parent wins a special ed verdict, the attorney's fees get paid by the state. And so California was paying almost $50 million just in attorney's fees. And when they earmarked this money, they specifically said, nothing goes to the attorneys. And so I think the simple answer is that they understand that that if done properly, it can save them money. And what they're finding is if done properly, there's greater satisfaction from the users. That's my answer, because we have a short time.
Jim, did you have something you want to say? Because I want to take a half 30
Yeah,
seconds.
real quick, related to what Michael just said. I think on the part of courts and agencies, it's always had the potential and has, I think, realized that potential of clearing out the logjam of cases. Efficiency. We can get a lot more resolutions, and parties seem to be even more satisfied with those resolutions from a procedural justice framework, Nancy, in mediation than they are in the traditional litigation setting. I'm sorry, Kelly, there we are.
No, you're good. You're good. And I can talk to Nancy privately because but I will just say you had some great questions, Nancy, in your intro this morning. And I wrote down, can you faking it, and then is it providing procedural justice? And I have to say, I know I have teachers and some administrators that come into that room totally faking it. They do not want to be there. They think that this parent is the worst, or this child is, getting what they need or anything else. But that's okay as long as they're there, and they do learn, and some of them make it after they've been faking it. So that's part of it. The other piece is that I can say, no, my parents are not all getting procedural justice. My schools are not after this meeting, but they are talking more and they are working together. So then what is your definition of success? And I think it's different in a program like mine than in some of the bigger programs and the bigger issues, when it's just money and it's just settlement conferences and it's really not getting people.
So thank you to our wonderful panelists and getting us up to speed.
So welcome to the second panel, different frames for assessing what mediator provides. What mediation provides, we have three wonderful panelists: Lisa Blumgren Amsler, Isabel Gunning, Michael Moffitt. I will read each of their bios as I introduce them. And I want to start with the bio for Lisa Blumgren Amsler. She is the distinguished professor that has served on the faculty of Indiana University, Paul H. O'Neill School of Public and Environmental Affairs since 1992. She has a law degree from the University of Connecticut School of Law. She practiced labor and employment law for a number of years. She's a Saltman Senior Scholar at William S. Boyd School of Law. The discussions and dispute resolution, the formative articles, ended up naming her article Employment Arbitration, the repeat player effect as a foundational to the field of arbitration. Her lead article on workplace mediation with Cynthia Halberlin and Denise Walker and Monte Chung is published in the Harvard Negotiation Law Review and is among the most downloaded articles on social science research network. Her research was noted by the ABA section of dispute resolution, and she received an award for outstanding scholarly work. And her book, Dispute System Design, Preventing Management and Resolving Conflict, received the International Association for Conflict Management 2022, the Outstanding Award. I'd like to introduce Lisa as our next speaker. In terms of that, I'd like to start that conversation with a question. So I'll start out the discussion by saying, Lisa, I know there's a question you would like to get an answer to. And I mention this as an introduction so that all of you will know she wants an answer to this question. And her question is, how do we deal with market forces driving jury trials for custody battles? And now I introduce Lisa, who will be giving a presentation, and I hope that you will address that question during her presentation thereafter, even though I know you won't.
So what I want to talk about briefly is the analytic framework for dispute system design, the first draft of which was actually written by my co-authors, Janet Martinez and Stephanie Smith. And then talk about this in relation to what's happening in Texas and this collaborative law section project, which involves Richard Cannon as chair, Kay Elliott, who was introduced before by Nancy, and Walter Wright, among others. So, and now this is not working anymore. Okay. So this, nothing is working anymore.
Hang on.
Okay, well, I can tell you that I can tell you a story. And it's actually something that I was shocked to learn this year. I don't know how many people already know this, and I felt like an idiot. But it turns out that the employees of the federal court system in the United States are not covered by Title VII of the Civil Rights Act. How many people in this room knew that? I'm getting a couple of hands up, 3 hands up. It's working now?
I think so.
Yeah, yay, okay. So I'm on a panel of the National Academy of Public Administration with the Federal Judicial Center, looking at an employment dispute resolution model plan that was adopted by the Judicial Conference chaired by the Chief Justice of the Supreme Court. And under this plan, every federal court has to adopt some version of the model plan, but they don't need to they don't need to be the same. It's not uniform. They can make any changes they want in the model plan. That means going from the circuit courts of appeals down to bankruptcy court, every employment dispute resolution system design can be different in an individual court. And so that's why dispute system design is an important thing. And how do we think about what courts do to implement dispute resolution? And when you think about, for example, the ADR Act of 1998, the Congress legislated you have to adopt a dispute resolution plan for litigants. This wasn't about court employees, litigants, right? No two have to be alike. Judges have amazing power, and that's not just true in the federal courts. It's true in the state courts. So dispute system design, I'm going to whip through these. The birth of dispute system design, most people pin on the book by Uri Breton Goldberg, Getting Disputes Resolved. And these are a couple of slides from their book talking about how the standard system design in organizations is largely based on power primarily, when it should be based on interests primarily. And they then gave us a way of visualizing the pieces of a dispute system design, including where are the different kinds of conflicts. And notice the yellow egg. It's because the system is nested in something else, and they identified that in terms of the environment, social, economic, cultural, factors, all of this actually relates to work done by my colleague the late Eleanor Ostrom, the first woman to win a Nobel Prize in economics, even though she was political scientist. So this similar structure gets you thinking about, okay, how are all these differences? Why are they different and how are they different? So my colleagues, Jen and Stephanie, in their first article, it had the 5 elements of this analytic framework. It did not have context and culture, which was added when we did the book, thanks to reviewers, and Nancy reviewed the book and gave us many wonderful suggestions, and Mariana Hernandez Crespo Gonstead, for those of you who know her from St. Thomas, was responsible for the context and culture piece. But there are 5 categories in their analytic framework paper in Harvard and 6 in the book. And these are goals. I mean, they're easy to remember. Goals, stakeholders, context and culture, processes and structure, resources, and then this notion of success, accountability, and learning. That's pretty straightforward. They then built out a series of questions for each one that you can apply to any of these systems. And I'm going to whip through them because they're here. You can take the slides and use them if you want. But the way that they initially framed these questions, they're sort of neutral facing and very accessible. I'm not a very neutral person, so you'll hear my sort of implicit stuff following each slide. So we're looking first of all at this question of goals. Well, you know, a lot of these systems are built around efficiency, right? But the cost savings, limiting liability, then there's what kinds of, we've got employment, special ed, consumer, environment, litigation, foreign direct investment. But what's implicit is some form of justice. And it may simply be distributive justice and money, maybe procedural justice, maybe other kinds of, for example, community restorative justice. Stakeholders, who are the stakeholders? What are their interests? Are they being represented in the design of this system? Or is that brings us the implicit thing, power. Some stakeholders are going to have more power than other stakeholders. And we know from non-union employment arbitration. I have to stop for a minute. I was a labor lawyer. I worked for the Connecticut Education Association as a law student. I wanted to be a union lawyer. There were no union jobs. My advisor said that there was this one management firm that did public sector stuff and you wouldn't be labeled as a union buster. It was great. I loved it. I did it for 10 years. It was wonderful representing people who were on school boards, municipalities, and all that stuff. And I fell in love with labor law because it's workplace democracy. So I really don't care about mediation. I care about mediation in the context of a democratic structure. And depending on how systems are designed, it may or may not function that way. Hence the repeat player arbitration stuff I got into. All right, so this question of power, who controls the design? Because who controls the design will also tell you who's motivated to do what kind of design, and that will tell you how the design functions in terms of that person walking in as one of the disputes. And so this question of context, we're going to have the design of the system reflect its context in part. So if you think about papers that have been written and litigation over arrests that happen in a Native American Indian reservation versus people who are from off the reservation and who's got jurisdiction over that kind of case, right? That context, how it's going to be handled within the system for handling conflict over potentially criminal conduct within the reservation is going to be very different from the context of the state within its embedded in that state criminal code. These aspects of culture and are also going to shape norms of communication in a system. And that was a lot of what Kelly was talking about when we think about, you know, a mediation system and a facilitation system. And it's great to hear that word used for special ed cases. The implicit stuff that's going on is we're all over the place. Look at what we talked about in terms of this new Singapore Convention. And I have no opinion on the Singapore Convention. I don't know enough. I was channeling Ron Kelly for what it's worth. And I appreciate the response, Michael and Jim. I appreciate the response. And I continue hopefully to learn a little bit about this. But when we think about all these different contexts, they will shape what can happen, hence Eleanor Ostrom. All right, processes and structures. Well, this one key piece of this is where are those processes and structures coming from? And Eleanor Ostrom tells us that rules on paper and rules in use, law shapes what can happen in an action arena, and mediation and arbitration and special ed mediation and facilitation are action arenas where we're bringing people together to work out a problem, right? They are shaped by what the rules are, which is one problem why we're not, I can talk about what it's like to be in a PA school privately with you afterwards, but people don't necessarily pay attention to the rules. So when we think about how it is that these structures are shaped, it's not only law on paper, but it's also norms. It's practices, it's the cultural context. And this can shape how people behave in the action. So then we have this question of resources. What financial resources support the system? Implicit in this is, where's the money going to come from? And what's costing people money that makes them interested in changing the system? These are incentives and disincentives in terms of how they create the system if they've got the power. And think about the legislature versus the courts. Let's loop back. The legislature can pass gently. They know the judicial branch is very independent. They can pass certain statutes, and Texas, I was saying to my students 20 years ago, has one of the best legal frameworks and earliest legal frameworks for mediation in the country. And so when people came up to me at the Texas Association of Mediators Conference and told me about this problem with family law in the trial courts, I frankly couldn't get it and didn't understand. So then this success, accountability, and learning. Most lawyers, Colin, and I know you're not a lawyer, Colin accepted, are Luddites. We're not good about technology, especially people in practice. And people and the courts don't have the resources necessarily to collect data. And I chaired a research committee for the ABA section of dispute resolution. We did a survey of all the ADR program administrators in courts. There were 10 basic fields they wanted to collect and couldn't at the time. Now that was probably 15 years ago. So this question of how do we know what's happening in the systems, how transparent they are? Well, implicit is who's got control of the information? What are they doing with it? How do we get hold of it? And who's got the energy or the money to analyze it? And this is not something that happens easily in the court system. And then there's also this question, how do they define success? And so that brings me, how am I doing on time? Okay, so that brings me to this question of courts and families in Texas. So this question of my example of the Indiana family court and hearing about what's happening in the civil trial court with 60% of the cases being divorce and custody led me to continued conversations with people And I went digging on the Association of Family and Conciliation Courts website for all their models of standards for mediation practice in family and divorce mediation. It's a great website, a whole bunch of different models for practice. And I didn't know when I was doing that Kelly and Peter Salem, who's in charge of that website or has been for years, have just done an edited volume on this. So this is wonderful. It's a tremendous resource. But my question to you is, especially for people watching this who are in the Texas state jurisdiction, is there something wrong with the system design here? And part of it is, even though collaborative law, this is what I hear from the committee, is that there are 19 community dispute resolution centers in Texas. They're all different in terms of their organization, their caseload, the way in which they're exercising their jurisdiction and cases that are referred to them. And the Texas Collaborative Law ADR Innovations team is trying to develop a very different way of thinking about dispute system design, not a way I ever thought about it. Specifically, they have identified that the culture in Texas of lawyering is driving the caseload in the civil trial courts surrounding divorce and custody. People who are involved in a divorce go to a lawyer, and the lawyer can tell them about the possibility of a case being referred to a mediator. Depending on where you are in the state, that mediator may be a retired judge. And retired judges handle mediation more like early neutral evaluation. The model of mediation they're using may be called mediation, but it may not be what a community mediator calls mediation. We have all these different models of mediation, all these different cultures and practices. Law schools, I believe, Nancy, you told me you have a 1 credit hour required ADR course. ADR's it's not required. Now the bar exam is changing and ADR will be on the new bar. But that doesn't mean that this is required curriculum. So you have people going out into the practice of law who know diddly squat about dispute resolution, but they do know they have to earn money. And how do they earn money, right? So this question of where the money is coming from, follow the money, it's from litigation in court. So if we follow the money, then the question is, people are spending, I was in the cab from the airport and the cab driver was telling me he went to a lawyer for the divorce that his wife asked for. The lawyer said it was only going to cost $3,500. Then he got a bill after that for $7,000 and he's just gotten another bill for $7,000. This happened yesterday. Okay, so why? What is it about the system that's driving this market, and how do you fix it? I am not a family lawyer. So their design, what they started talking about is, let's change the way that courts are thinking about design. Now, how they get them to do that is a question. But this is a piece of the committee's interim report from last year that Kay Elliott, who's an adjunct here at Aggie, whose late husband was the first dean, whose chair Nancy now occupies, she sent me this. And these are all different names for different processes that people don't know exist, that lawyers may not know exist. And so how can the people caught in that market advise their clients? So we go from, I'm not going to go through we're dispute resolution people in this room. I don't need to do this, but you can talk to members of the committee if you like. And this is a quote from the chair of the committee. And this is what I didn't think about. This notion that if we combine the role of convener with dispute system designer, and we actually embed somebody who does that within the courts or organizations, and they, or in a dispute resolution center, of which there are 29, and we get everybody who wants a divorce or has a custody battle referred to somebody like that first before they go necessarily to a lawyer, or as part of once they've been referred to a lawyer. And then or if we had lawyers who were trained to do this, and dispute system design is an elective in maybe 5 law schools, right? Then that person, that expert, that convener could work with that individual and the other individual who's the other party to the divorce or litigation, and tell them what their choices were that might in fact be cheaper and more affordable for them, and different ways of doing it that would not cause all this angst and pain, financial and otherwise. So this notion of dispute system design framed as a system, it's for encompassing a stream of cases, few electives in law schools. What if we had dispute system designers embedded somehow in the process for people getting into these market-driven litigations? And that's it. And these are a bunch of references, including Kelly's new book that's coming out April 12th. And they're not the only references, but they fit on one page. So now I'm sitting down.
Right, so I know that the only thing that will be holding us up is lunch, so I'm gonna go a little bit faster after this, because I know lunch has a priority to some people, even more than the greater things you'll hear. Our next panelist is Isabel Gunning. She's motivated to study law in order to support progressive challenges in our larger society. She was a criminal defense attorney with the Public Defender Service in Washington, D.C., and a human rights attorney with South Africa. She also writes in the area of religious and spiritual lawyering. She is the Mayor Tom Bradley Professor of Law at Southwestern Law School, and she is also licensed as a practitioner and spiritual counselor by her home church, the Agape International Spiritual Center. To start our discussion, Isabel, I'd kind of like to see about how you would talk about any thoughts you have on what we can look to in terms of historical developments about mediation that still give us some hope about mediation today. Thank you.
Thank you. Good morning, everybody. And I want to not only thank Michael, but all the organizers for inviting me to this annual dispute resolution symposium. It's terrific. So thank you. I'm going to talk about history. And of course, Nancy did some of that as well. And I guess my framing will be a little bit different. And I've entitled my remarks Sankofa, recalling our history to find reasons for hope in mediation. And Sankofa is a word from the Twi language, a language spoken by people who live largely in what is now known as Ghana, which is in West Africa. And it represents an African concept that means to go back and fetch it. And this means that one recalls what one might have forgotten from the past, and uses these originals, lessons, or values to build for the future. So that's why I want to talk about our history, a little more detail. Yes? How much louder do I need to speak?
The microphone, I raised it.
The microphone is right. What I'm looking at?
Yeah.
Oh, okay. Anyway, so I'm going to talk about our history and the range of original values that birthed us. So I just want to say what I'm presenting is part of a larger collaborative project that I'm engaged in with Professor Sharon Press, Ellen Deason, who might be online. So hi guys, yay. Sharon and Ellen published a terrific piece in the 2021 Cardozo Journal of Conflict Resolution entitled Mediation. Embedded Assumptions of Whiteness. And I referenced their piece when I published a piece after theirs in the 2022 WashU Journal of Law and Policy entitled Justice for All in Mediation. Sharon, Ellen, and I focused in our articles on the racial reckoning which grew out of the public murder, or lynching, if you will, of George Floyd. And in our pieces, we three shared concerns on the impact of the assumption of whiteness or white supremacy in our own mediation processes, and have since been presenting on this issue and sharing conversations with other DR professionals and scholars in discussions like a conversation about white supremacy, racism, and mediator neutrality. And all of these presentations are around questions relating to being anti-racist as mediators and maintaining neutrality or impartiality. So Melissa said, oh, they're questioning neutrality or impartiality. That's exactly what we're talking about. And where we're gonna land, I think, is gonna be a very important question. And so this larger project has involved us looking back at the history of ADR in the United States, and I wanna focus particularly on mediation. I wanna start, though, our looking back with a quote from Jerome T. Barrett's seminal work, A History of Alternative Dispute Resolution, the story of a political, cultural, and social movement, where he says, and I'm doing some editing, quote, from an ancient Phoenician negotiating an agreement in the Eastern Mediterranean in 700 BC, or a Chinese mediator practicing in the Western Zhou dynasty 2,000 years ago, all the way to Kalahari Bushmen and Hawaiian Polynesians engaging community members in conflict resolving dialogue, to the formation of the United Nations, all societies have fashioned peaceful practices for resolving their conflicts. Our work is fundamentally peace work. We're not just keeping people out of courts, we are supporting people in resolving the whole range of conflicts that people have without violence. Now, we know the contemporary ADR movement in the US had its beginning in the 1960s. With the successful use of ADR processes in both commercial and then the labor capital struggle context, as Nancy mentioned, these processes, both arbitration and mediation, were imported into the community context. We know the origins of community dispute resolution is in the Community Relations Service, which was part of the Civil Rights Act of 1964. And what we now call merely mediation was called community mediation in those early years. And community mediation grew out of the social and political activism of the 1960s, but evolved along two somewhat separate but interrelated paths, both of which felt the court was not working for everyone. So one focused on responding to the perceived inefficiency of the court system, and the other focused on responding to the civil rights protests, Black Power movement activisms, feminist challenges, and urban uprisings, all raising the continuing issues of social inequality and injustice in the American society. We tend to reflect back on the first path. We often go back and fetch the famous 1976 National Conference on the Causes of Popular Dissatisfaction and Administration of Justice, the Pound Conference, because of our beloved Frank Sanders. That's where his seminal work started out, talking about court-connected mediation and the use of appropriate ADR processes through the use of government itself via the court system. And we're often going back and fetching his insightful word, just like we did today. And as many of you have done very successfully, both critiquing and improving on that history in order to improve the present and future of mediation. I want us to go back and fetch the insights from the other path of our history. This path, which intended to participate in and respond to civil rights and Black Power activism, to feminism, and to other social justice agitations. The path that was focused on transforming our society well beyond improving efficiency in the courthouse. These are the community-based groups that developed that were interested in democratic participation. The idea was to empower community members and to involve networks of community organizations, not only in humanizing each other, but also in creating alternatives to the court system that would truly be fair and just. Many of these programs intended to be part of a larger social, political, and economic movement intended to make systemic change in the United States, including the eradication of inequality based on race and challenging the concentration of economic and political power in the hands of a small minority of Americans. This work in particular was designed to create nonviolent approaches to change and transform the longstanding systemic inequalities of American society. Some of you may recall it more personally, not the young people who are here. The 1960s represented a time when organized resistance was reawakened and pushed back against the violence of Jim Crow, segregation, discrimination, and inequality. And this persistent nonviolent resistance was being met with state and police violence, which in turn resulted in violent uprisings in impoverished communities of color. This was another time of racial reckoning. Some have called the 1960s the second Reconstruction, since the work of the civil rights and Black Power movements, along with the social justice movements that they birthed, were really about the work of completing the first Reconstruction after Civil War. Radical Reconstruction, a time when our nation had the chance to actually live its values and start on the path to a truly democratic nation that valued all individuals and communities equally. A time when equality for all might be made real. And we started to do that great work in Radical Reconstruction, and then we failed. And the 1960s represented round two to finally make equality happen for reals. Professors Patrick Coy and Timothy Hadeen note that in the first 2 decades of the community mediation movement, the quote, desire was to provide local citizenry with a neighborhood-based, grassroots alternative to the justice system. The building of not just parallel, but truly alternative approaches to the government-controlled and court-focused criminal justice system was the motivating factor for many. Community building and empowerment were central to mediation's mission and approach, end quote. These were heady times when the successes and the shortcomings of the civil rights movement, the peace movement, the environmental movement combined to give hope that local citizens and neighborhoods could, quote, reclaim control over the conflicts that affected their daily lives, mediate them in constructive ways, and eventually bring about social change in the process. Complementing this stance was the deep-seated commitment by some of the founders of the field to using mediation and other forms of conflict intervention to redress power differentials in social and political conflicts. The goals of these two branches or paths of community mediation, while intersecting in some ways, also diverge significantly. While both forms of mediation support individual party satisfaction, at least some of the early forms of community mediation intended to challenge and change the larger social, political, and economic system in the United States. So, what does going back and fetching this part of history mean for us? If we were literally born out of an earlier racial reckoning, a second Reconstruction, do we have a role now in the current racial reckoning, or what some scholars and activists are calling the third Reconstruction? If we are the descendants of a movement that saw mediation both as a means for individuals to get satisfactory resolutions and possibly personal transformation, and as a social movement that could redress power differentials and make systemic changes across the society, what are our mediation values beyond impartiality, self-determination, and confidentiality? It will not surprise those of you who know anything of my work that I want us to go back and fetch these roots in order to reincorporate our historical values of equality, justice, and fairness, along with individual as well as community empowerment back into our core values. I know that we as a dispute resolution community have responded to concerns about inequality and especially racial inequality. I don't want to deny that. My friend and collaborator Sharon Press was calling for diversification of the mediator pool and enhancement of mediator training back in 2011. She cited the great writings of Professor Phyllis Bernard, who did terrific work in Oklahoma around mediator training and to eliminate bias. And of course, Professor Carol Izumi's work on implicit bias has been foundational. These calls for work on eliminating bias, explicit and implicit, have rightfully continued and been expanded, and all manner of great ideas on how to provide participants more information and preparation have been presented and still need to be pushed. I do not want to overlook the work that we've done, and I still believe we need to do even more. And that more involves looking at our core goals and values. I think we should look to our siblings in the restorative justice arena. It's not that I think they've figured everything out, but I know that RJ practitioners of color have been challenging the field to transform itself. One of RJ's prominent thinkers and scholars, Dr. Fania Davis, describes this as, quote, the restorative justice's emerging self-image as a social justice movement, a modality of both systemic and relational transformations, end quote. We as mediators should be called upon at this critical moment in both our country and the planet's history. And if our work as mediators, both at the individual and community levels, and I don't suggest that the work will look the same in those two different contexts, but if we're to do more than be a safe space where legitimate concerns for structural and systemic inequality are merely placated and calmed, but not altered in any way, then we have to take a hard look at where we stand on other values like anti-racism, social justice, and equality. I have in the past advocated for more activist mediation, where I referred to shared values or American creed values being openly discussed in the mediation. And maybe I was naive. Our DR colleague and my fellow critter, Andrew Amato, has noted in his work, quote, it is far from clear in our polarized times whether there is a coherent set of shared values at the heart of our society that would constitute an American creed. I think the significant part of Andrew's piece is that he reminds us of Professor Derek Bell's terrific scholarship, in particular, his work on interest convergence. There, Bell reminds us that the legal principle of equality in American law remains subordinate to the tacit belief among whites that their superior social position would always be maintained. So thus, to merely assert that we have shared values of equality or fairness leaves uninterrogated what the unspoken differing assumptions white versus blacks may have about these seemingly shared qualities. So are we talking about social justice now? Can we be like some of the community mediation programs that have stepped back from community mediation having any part in ameliorating or eliminating individual social ills? I'm going to try to cut down on this quote because I see Michael, he's sending me daggers. So I'm going to stop looking. I'm going to stop looking at it. Hurry up, no. 2019 document, I want to be clear about it. It's the state of community mediation. There were a number of co-sponsors, and there, while they acknowledge our history is coming out of the civil rights movement, they say CMC does not provide social justice as typically defined. The purpose of community mediation is not to determine one truth or to balance unequal power dynamics rooted in social status, race, or gender. Instead, community mediation endeavors to create a supportive and safe environment that encourages free and open expression of everyone's respective truths, end quote. So can we support everyone's respective truths in this day and age and not end up supporting the status quo? Or worse, will we end up on the sidelines as authoritarianism takes hold in our nation and hard-fought equality rights for marginalized groups and individuals, nation as they may be, get undermined and eliminated when our very democracy is in danger? I've long had concerns about mediators having a concern for the justice of substantive outcomes. Nancy and I have had conversations, procedural justice, substantive justice. There's no easy solution to how we're going to ensure that there aren't unconscionable outcomes. But I do think it's important for us to not move on to all of the important issues around online mediation without bringing this important conundrum into that arena as well. I mean, the last piece I want to say is, of course, we want to think about how are we going to do mediation in a way that doesn't lead to unconscionable outcomes. And again, my buddy Andrew talks about using dialogue. And I love dialogue. If anybody knows my work, I'm always talking about community dialogue and how can we bring the lessons of that into more one-on-one mediations. And he speaks about, it's just a sketch, right? A relationship-driven dialogue rooted in empathy. And I want to think about that empathy out of Isabel Wilkerson's great work, her book, Cast, The Origins of Our Discontent. Because she taught you, let me just say this, right? Her book is about, documents the history of a hidden caste system, a rigid hierarchy of human rankings that has infused American society since our beginning. And she understands caste as undergirding all of the more obvious divisions like race or class. And she posits that if we have any chance to combat that kind of caste system, we need radical empathy. She defines that as putting in the work to educate oneself, to listen with a humble heart, to understand another's experience from their perspective, not as we imagine we would feel. This work wouldn't just be for us as mediators, it's the work that we'd have to encourage participants to do within the mediation so that we could unearth whatever unspoken assumptions exist around fairness or justice or equality. And the important thing to note about Wilkerson's radical empathy, yes, it is about seeing and connecting with the humanity of each person, but it is not an empathy that accepts everyone's respective truths. It's an empathy that understands we have a caste system and there are some people at the bottom and some at the top, and includes elevating those at the bottom. So what will it mean for us? As I said before, we're going to have to interrogate and talk about what we understand to be impartiality or neutrality. What are the values behind the values of impartiality or neutrality that we hang on to and know that we need? Is it about trust? Is it about some other value? Whatever it is, for me, what we will do as mediators to fulfill the hopes for mediation going forward, I hope it's going to be to reclaim these values of equality, fairness, and justice from our roots and bring them back to today and finding ways to include them in our current practices and goals. These are my reasons for my hope in mediation for the future, and the future is one in which our work is absolutely essential. Thank you very much.
Thank you. Last but not least, our next speaker, Michael Moffitt, is the Philip H.K. Knight Chair in Law at the University of Oregon, where he teaches as faculty in residence at the Clark Honors College. He previously served for 6 years as the Dean of the Law School at the University of Oregon and as the Roger D. Fisher Visiting Professor at Harvard Law School for 2 years. Before becoming a professor, he was a consultant with conflict management. He continues to practice as a mediator, and he tells us that his hair is not always been blue. Welcome, Michael.
Appreciate it. So, while we're getting the PowerPoint stuff going. So, Nancy is inviting us to think back over some decades of the history of mediation, if not longer. And Isabel, I really appreciate your contextualization that goes beyond a few decades. Really appreciate that very much. I started my think back largely by looking back at Nancy's work, thinking that that was an appropriate number of decades, at least for a party that she was throwing. And it occurred to me that there is this, I don't know if you've ever done this, but I was going to get a picture of Nancy from the days of her early, so Nancy in the 90s. I was going to, and I thought, oh my gosh, that is a terrible idea. But then it occurred to me that you can ask AI these days to generate images. You can upload an image and say, you know, what did you look like in the year 2000? And they will do a horrifying job of doing it. And I thought, I have to find out what that looks like, right? But I couldn't do it with Nancy's picture because that's just so rude, right? So I did it with mine, and that's what they thought I looked like in the year 2000. I'm just going to move on from that very quickly. That's awful. Starting about 25 years ago, I started noticing, with all love and affection for mediation, that I never heard any cautionary tales. I only heard heroic stories of mediators doing good things. And there's a good reason for that, right? And I think we could probably tell an institutionalization story about why that might have been happening, right? We were trying to promote its good use. But we really weren't hearing anything about mediators doing badly. At the very most, what we were hearing were squabbles about, I wish they would have mediated this way as opposed to that way, but not really awful stories about mediation. And so it seemed to me that there were really only three possibilities for why we might not hear bad stories, right? It might be that mediators are perfect. It might be that we don't talk about unpleasantness, or it might be that mediators just aren't getting in trouble. So the first seems super easy to dismiss, right? Just even super basic Greek philosophy would go something like this. Mediators are humans. Humans sometimes screw up. Therefore, mediators sometimes screw up, right? That logic is just hard to argue with. The second, that we don't talk about unpleasantness in law schools, that cannot be the answer, right? I mean, if law school pedagogy has taught us nothing, it is that apparently the way we're supposed to learn things is by watching when it goes badly, right? You just spend all day in law school reading about stories with unhappy endings. So that cannot be it. So then I thought, well, could it really be number three, that mediators really aren't getting in trouble for being bad? And so that became an empirical question, and
This needs to share this.
please do, although they missed the really cool photo. Do not. So this green bubble, this really are mediators not getting into trouble, became the focus of a whole bunch of empirical work for me. And the short answer is, yeah, mediators really aren't getting in trouble. They really aren't getting sued much of ever. And so really I published some articles, and in exchange, the Academy offered me tenure. And my articles can largely, I'll save you. I largely said three things. I basically said, mediators aren't getting sued. No matter how hard you hunt for these cases, you're not going to find them. Point number one. Point number two, the reason they're not getting sued is because of the legal system in which mediators are operating. The way malpractice laws work, the way confidentiality works, the way immunity works. There's a whole bunch of reasons and a whole bunch of footnotes, but trust me, number two is true. And then I said, this will not last. This is not something mediators should get accustomed to. And I pointed back to the history of medical malpractice. Used to be a rider on doctors' homeowners insurance and cost no more than $1. Legal malpractice, you couldn't purchase 70 years ago. It didn't exist. Legal malpractice insurance didn't exist. And so I said, mediators beware, the sky is going to fall, so get used to it. And then I got tenure, and then I went on with life. And then like 20 years later, Nancy called me. And it occurred to me that I must have been wrong. And I can say that I have tenure, right? But I must have been wrong, because either, since the laws haven't changed, either mediators are now getting sued a bunch, in which case my legal analysis was wrong, or mediators still aren't getting sued a bunch, in which case the end really was not very nigh. But I wasn't sure which, right? So what I began doing was searching again for complaints against mediators, just to find out, are there people out there angry enough at the bad stuff their mediators did that we can find evidence of their complaints in the form of lawsuits or other kinds of complaints? The headline is, you can find some, but not a lot. 10 days ago, there was a complaint against a mediator out of Houston, I'll say, where the mediator was alleged to have breached confidentiality. There was a Dallas case in which a mediator was alleged to have engaged in bias both on race and disability status. There was a breach of fiduciary duty case out of Houston. There was also one in Colorado. I'm not speaking on Texas. I'm trying to, be local-ish. There was an undisclosed conflict of interest case where I learned from one of my professional responsibility colleagues that there was a survey of lawyers, this is an aside, where the question asked confidentially was, how many of you have ever slept with your client? Which seems a bold question. And the answer was 7% of lawyers admitted that they had. 30-something% said they knew a colleague who had. I have never found a case of a mediator who had, and you can make whatever meaning of that you want. But there was a case in New York where the mediator's daughter was sleeping with one of the clients in the mediation, and there was a complaint about that. There was a California case in which a mediator was accused of committing fraud. Connecticut cases in which the mediator drafted things badly or inflicted emotional distress. There have been a bunch of negligence-related cases. But there aren't a lot. And the plaintiff didn't win in any of these. You can't find them where the mediator actually was found liable. You just hear bad stories, and then the mediator wins. And so, thinking about the implications of this, by the way, search methods, I don't know how to find these things. There is a real chance that the way I'm searching is messing up the results. I'm trying hard to go beyond just reported cases because that has all kinds of limiting biases. I've talked to malpractice insurance salespeople. I've talked to malpractice underwriters. We've looked at court systems. We're looking really, really hard and we're not finding much. But what are the implications of all this? I think that there are some practice implications, right? Somehow, for some reason, in spite of the fact that there are a bazillion mediations going on every year, and I'm going to cite Michael for that number. There's a bunch of mediations going on and lead mediators are never getting found liable for it. And yet mediation clauses increasingly have waiver provisions in them. Questionably enforceable, but they're in there. And malpractice insurance still costs more than a latte, and I can't figure out why. Just from a math perspective, I can't figure out why that is. But there are implications. There are teaching implications for those of us who teach. I do think some of these cases make for interesting discussions, even though the punchline to the story is, but the mediator wasn't found liable. I think from a policy perspective, and this is where I'll stop, lest Professor Green hold up some small number of fingers. Oh, look at that. We have some enduring policy questions in our field that don't seem to be connected with the actual lived experience of unhappy mediation parties. There have to be some unhappy mediation parties, not just unhappy because that other side was a jerk, but because the mediator did something bad. It just has to be true. We have an immunity system, both qualified immunity and quasi-judicial immunity in a lot of ways that Art Henshaw can teach us about, that is not going away. We have a set of confidentiality laws, and these have been some of the most robust debates within our community, at least for the decades that Nancy and I have been teaching. And there are some good faith arguments about the necessity of and the boundaries of confidentiality in order for mediation to fulfill its highest goals. Another lens on confidentiality protections would be through the lens of the potential for shenanigans. And I'm not sure that that one has been elevated in quite the same way, in most states. There are policy implications about what, if any, data we ought to be tracking about complaints. God forbid we have a Yelp review system for mediators. But I'm not sure that's worse than nothing, right? We've got Rate My Professor doing all kinds of horrible things in the academy. Maybe we should impose that on, no, don't, that's a terrible idea. But the market for mediation is profoundly broken. The proxies for predicting who will be an effective mediator by whatever metrics one measures effectiveness are really hard to pick apart. And the market for mediators is not a leveraged one. You have very, very few large mediation firms because you can't piece apart a bunch of mediation practice. And so people like me get hired to do mediations over and over, in part because I've done them. That turns out not to be the greatest. That's not the worst predictor, but it's not the greatest. How do you know who's good? You can say more about how the market is broken, but one part that is missing from the market is evidence that people are happy or unhappy with the mediator. And then there's a set of, we've already touched on, questions of licensure or certification, and Michael and Art. I disagree with both of them about this. I also disagree with myself about this. I think this is just a damnably hard question, but I will note, in support of the case that Professor Colatreo is making, to the extent we don't have a licensure regime, we cannot ask a complaint mechanism to do much work for us because there is nothing to take away, right? We can think what we want to think about the bar and the prospect of disbarment and what lawyer quality control looks like, but at least they have something to take away. There is no state that can prevent me from printing up business cards that say mediator for any grounds, no matter what I have done. Again, I'm not sure that I'm ready to grant the state that power, but I will note that it creates part of the legal ecosystem in which it is true that mediators are never getting sued successfully. I'm going to pause there.
Thank you. So any questions for our panelists? Yes.
So I have one that might tie some of your presentations together, which is this question of how do you ensure you're getting a quality mediator? And I would say that one way you do it in the current marketplace is you get somebody from a panel, CPR, AAA, JAMS. But there's also a lot of data out there that suggests that there's pipeline problems, that the panels tend not to be diverse in terms of women and people of color. So I guess one of my concerns about, any sort of these vetting programs is that it's going to end up excluding, and who gets included is, going to look a lot like who's currently the main source mediators, which tend to be older white men. I guess it's not a question. I guess it's a statement that I want you to react to.
Yep, that seems right. One hopeful, and in keeping with the theme, one less hopeful observation. The hopeful observation is that you are absolutely right that panels play an important role in marketplaces. The hopeful piece of that is panels are not government actors. The government has, in most contexts, outsource that to CPR or to AAA, whoever it might be. Which means that we at least could imagine that in a marketplace where there is some demand for this service, you'll get a diversity of approaches to it, right? If you get CPR to decide it's going to change the way it does its panels, you don't have to get the state legislature to decide. So I think that there is a nimbleness to it that gives me some hope. The less hopeful part is that I also surveyed the panels that I could think of to ask for any information about any instance in which any member of any panel was ever kicked off the panel for misconduct. And the only misconduct any panel could ever identify ever was a mediator whose misconduct was they didn't pay the annual fee to the. So,
Did you look into her hand up? Go ahead.
Again, in the fantasy life of system design, 25 years ago, I did an empirical study on community mediation centers, at which point there were about 350 of them that were members of the National Association for Community Mediation. And there was also at that time, although it's now dead, the National Victim Offender Mediation Association. And so there's, and you think back to community mediation, and I only know this because I'm married to the person who used to be the executive director of community boards for a decade in San Francisco. And their setup was all these mediators were trained by community boards, but they all came out of the community. And the people employed by community boards could not mediate. It was against the rules. It had to be somebody from the community. So this question of where are we getting the mediate? I mean, this is another panel possibility. There used to be 12 mediation centers in Indiana, including the first one that Mark Umbright wrote about. But there are three, there are maybe two now. And that's even though, like California, there's a fee charged in the courts to support community mediation. California's works, Indiana's doesn't. So it's an alternative.
Yeah, I mean, I think that those are the kind of polls maybe, right? The boards really were that model of, you know, you're going to embed yourself in a particular community. You're going to have those folks be the ones who are thinking about who are going to be the source of who's going to be mediating. So you're going to have, and we talked about this over dinner, you know, how do you identify community? What are those values? So this ideal that you're going to have real alternative values, but they're not going to be kind of imposed, right? That's where that model is. And I think for me, that's part of why I'm hesitant about the licensing. You know, the old each one teach one, we're gonna have kind of, you know, conflict resolution is just a part of what we do. And then folks out of the community would in fact help people, right? So I'm concerned about that. I appreciate your saying, you know, let's remember that the JAMs and the CPRs are not actually governmental. So there might be an alternative way to do this. And I guess the question is, where do you get the money? That's what you talked about in your slide about the resources, right? Because, right, I mean, the people who finance these things kind of like you and your background better than somebody who is abuela on the block, right? Who actually has a lot of gifts and talents, actually has been meeting a lot of things in her family, in her community, and might be able to do some fabulous things, but they don't have a good way of seeing how we're going to acknowledge her talents and distinguish them from, I think Kelly was talking about the parent advocate who was so terrible, right? You know, you kind of have to have a way of recognizing the folks who have alternative talents and skills without, you know, bringing what we have a concern even, I mean, that's your worry, that there gotta be mediators out there who are in fact not quite neutral, right? They're awful, right? Yeah. Whether it's my neutrality, your neutrality, I mean, they're terrible, right. But we're not capturing that. So I think that really is the challenge. I think there is a hopefulness. how you frame that and fund that, I think becomes the real question.
And do we have a question back? Yeah. Yeah.
Just a couple of things, and I think it's interesting. I think some of what you guys have been talking about relates to what Michael was talking about earlier too, with licensure and how it works, because we just had this conversation, Michael, that you're talking about. I bring in the director of the ADR Commission in Arkansas to talk about ethics with my clinic class. And we talk about, complaints. And she's like, and we haven't had any in 2 years. And I said, is that a good thing or a bad thing? And she's like, it's horrible. Like, we know that there is not consistency. We know that some of these people don't do things, but we don't know how to bring that in. Like, we don't want to advertise, here's where you complain about your mediator, but we also want to make sure what is the connection between people who are complaining, and going back to Erin's point about who's mediating, we've got lawyers that are picking each other to mediate and then representing, and it's this very incestuous. And then they're not complaining about it. And then the parties, do they even know that it's something to complain about, that this isn't mediation? I mean, many of us have had that experience of going into mediation where someone's like, this is mediation, this isn't what I went through last time, and they don't know. And there's reasons for differences, but I think a lot of them don't know.
Is Colin Rule in the room? Is he still here?
He fled.
Okay, because I wanted to add, so just on this point that Kelly made, and it really goes to your point, Michael, it's really more of my observation. I saw Colin speak years and years and years ago, and he tells a story when he got to eBay, which I know many of you know, or was it PayPal? He got to be one of his first jobs designing dispute resolution systems for these online platforms. And so they said, we want to build this online platform for customer disputes. We really don't have many customer disputes, but we'd like to build this platform. Okay. So he builds this platform for streamlining customer disputes online. And all of a sudden they had all these disputes. And the head of, I think I'm paraphrasing Colin, I wish he was here to tell the story, but the gist of it was, you always had these disputes. You always had these problems. Now there's an outlet for people to voice those concerns. And of course, it made these platforms much more safe. And I don't think anyone has any problem going on eBay or PayPal, because we know that there is a guarantee that they make, and that there's a dispute resolution system. I've used it 3 or 4 times. All of it worked out great. And I think part of this issue of no complaints about mediators is, suing them is a really big hurdle to get through. But if you had a system, again, I'm open to flexibility in terms of whether it's a licensure, certification, or something. But what is I just happen to know, as many of us do, like, there's a lot of awful things happening, but there is no voice. There's no mechanism for a voice of the complaints.
Did anybody have any comment to that, or?
Well, there is actually some fantastic Jean Brett research on how that system functions. A version of it actually rewrites, it's like early AI, rewrites the complaint so that the language of the complaint online is less offensive to the receiving end of the complaint. And the settlement rate, of these complaints goes way up and it's much easier, much faster.
The only thing I would add, Michael, is totally agree. And building on Isabel's point, whose version of awful do we facilitate complaints about? Right? Because my vision of what god awful mediation looks like isn't going to match somebody else's. Very few people go into mediation thinking, today I shall be awful. Right? They go in thinking, I'm doing it right. I'm doing it well. They don't get much feedback on whether they're doing it. And I don't get much feedback on whether I'm doing it well. And so I probably have become a caricature of myself over the years, right? Because I just keep doing the same thing. I keep getting hired. I must be doing it well. That's terrible logic. And then layer on that we might have different systems going on. We might have different goals for mediation. It becomes very hard to say who's doing it as badly as I am positive they're doing it. So I just want to acknowledge that.
Yeah.
So let me see, I've got another question. Is this a follow-up to that? All right, so, and I see 3 more people, and we have 2 minutes to lunch. So maybe all 3 of you can mention your questions so we can hear them, and then we'll see if we have enough time. So Cynthia, and then you, sir, and then Art.
Michael, the idea that there aren't complaints and there must be something wrong, I think this exists in a lot of other areas too, right? We look at prosecutors, hardly any have any kind of misconduct or any other thing pending against them. And we know there's a lot wrong with what they're doing, right? And I think a piece of it may be, what Michael's talking about, there's no easy forum to bring these cases forward. We know there's a lot of police misconduct. There are many more complaints against police. But I think also when we set up a forum, like in Fort Worth, we've got the Office for Police Oversight, which is a fairly new office, and these are happening in other communities. It gives a forum to bring these complaints forward. But I don't think it's just a question of there's nothing to lose. I think it's a more complicated question about how much confidence do we generally in this society have that we're going to get anything from our complaints, or we've all been kind of gotten used to consumer services, no such thing, right? And we just suck it up because there's nothing we can do. I think there's a piece of kind of maybe learned helplessness that's at play in some of this. So I don't know. Those are just random thoughts.
All right, sir, why don't you state your question?
It's really more of a statement, but 1987 with the ADR Act in Texas, for about the first 4 or 5 years, it kind of had a flavor of an interdisciplinary. There were a lot of non-lawyer mediators that were actually in the ADR committee and became the ADR section, and they could be members of the state bar without a bar number until more attorneys became trained as mediators, and some of the non-attorney mediators were advertising members of the bar. And they said, oh, no, you can't do that. And then there was a licensed professional counselor in Dallas that actually was helping parties draft a divorce decree. And she was sued for unauthorized practice of law. So you saw a lot of the non-lawyers backing away in those after the first 4 or 5 years from being involved in mediation.
Very important history.
Art, you had a question?
I wanted to touch on Isabel's discussion of Wilkerson's radical empathy idea, and just have this sort of comment, sort of last question that we can discuss over lunch. Having read that book, I was really excited about this concept. And
Could you speak louder, Art?
yes, so the idea of radical empathy, and with Wilkerson's book that Isabel talked about, and it's a very seductive concept, as to what I want to say. And just recently, I was talking with a person who was a part of the Dayton Peace Accords, and I asked him about it, and he said, "You know what? This is the problem with diplomats. We think how we would feel in those shoes. We don't understand how they feel in those shoes." And he said, it's the hardest part of diplomacy. It's the most difficult thing for any of us to do. And my question is that, how do we do it then, right? That's the question.
But I don't know that hard means that we can't, right? I mean, it may mean that we keep trying, we're failing, and we probably need to get more information about what our failures look like so that we actually can improve, without it being in a black box, right? If I'm Michael Moffat, then maybe I'm okay, but otherwise I don't know, right? But I think it's so important, right? I mean, we need that not just for us as a profession and for the people in front of us, we need that in our country. Right? This idea that we might actually spend the time to understand from somebody else's perspective as opposed to say, oh, they're crazy. Oh, cray, right? So it's worth doing. And I admit, I mean, I'd like to have the magic formula and then you'd make me queen, which I would love. But
Yes, please.
but it's worth doing whatever that work is, because it's so necessary. That's my response to that.
I think we'll have to leave it at there because lunch is demanding that we go to it. So thank you all. Thank this wonderful panel. Here in mediation that we decided to have this conference about mediation. Thank you.
Thank you very much, Michael Green. So, hello, everybody. I'm Peter Riley, and I teach here at Texas A&M Law. Welcome to the second panel again. No, I'm here to do the third panel. Here to do the third panels. As we look to the future panel, So the way we're going to organize this is each of the three speakers will speak for about 15 minutes, and then we'll have a wider conversation with everybody else. So as Michael Green said earlier, my role here is to just simply introduce the talent, which I will do now. So Professor Aaron Archard is Associate Professor of Law at Detroit Mercy Law School. Recent articles, two of them caught my eye. Online mediation and the opportunity to rethink safety in mediation is one of them. Second one is evaluating mediation's future, hence being placed on the future panel. She's a graduate of Harvard Law School. Prior to going into academia, she did some corporate work for Covington and Burling in the San Francisco office. And in 2020, she received the University of Detroit Mercy's Faculty Achievement Award. So Professor Archard.
Peter. All right, I'm gonna put a stopwatch on to see if I can actually stay faithful to this 15-minute commitment that we made. My notes here. I think that as we enter into this afternoon, we're gonna see the various strands coming together. And I think a lot of what I say here follows up on some of the things that Isabel Gunning was saying earlier about these notions of justice and anti-racism and how these feed into our dispute resolution systems. My particular interest in restorative justice began as part of a larger project looking at students with disabilities and school resource officers. And the idea at that point was thinking about how are school resource officers being trained in conflict resolution and de-escalation. And at that time, a lot of the training programs were making mentions of things like mediation and restorative justice. So that was how I entered into this space. I think there was an open question about whether restorative justice is different than mediation. You know, is it one of the many processes that is a mediation-like process? So it just is mediation, or is this something entirely separate? I think in my mind, one of the areas where it's a little bit separate is that it is so rooted in this idea of peacemaking, which, as Isabel spoke of earlier, certainly was part of the early adoption of mediation in terms of community boards and the idea of mediation being a community-based process that I think has become increasingly distant. And so now most of the time, if you say mediation, especially to a lawyer, they're thinking about something like a court-annexed civil mediation process. I have this circular graphic here, in part because my title is Mediation's Lessons for Restorative Justice, but my conclusion is more maybe restorative justice has something to teach us about mediation going forward. I gave a version of this talk, by the way, to my faculty, and one of my faculty members, who's former prosecutor, made a remark that I thought really summed up some of what I had to say nicely. So I'm actually going to lead with it. He said, "Oh, so you're saying the process is cheapened in the name of results?" Yeah, that's a good summary. Okay. One of the things that I think is a lesson from mediation is the curve of adoption in terms of restorative justice as such being a relatively unknown or lesser known process 20 years ago. And today, almost every state has some form of law or regulation that mentions restorative justice or restorative practices. So there's been this rapid increase in adoption, and particularly in the criminal context and what I sometimes call the quasi-criminal context, which is schools. And so we're seeing it used in schools to address matters of student discipline and related to these ideas of the school to prison pipeline. And so schools are adopting restorative practices often as an alternative to things like suspension and expulsion. Hat tip here to professors like Talia Gonzalez at UC Law in San Francisco, who's done a lot of research. If you're interested in looking at sort of the codification and statutory adoption of restorative justice, she's really the person to be looking at. And then in the schools context, Lydia Nussbaum at UNLV wrote a really nice piece a few years back thinking about how restorative justice practices are being implemented in schools or not really implemented in schools. And her critiques were very cogent. I mean, it's what I am seeing today when I talk with practitioners doing restorative justice work in schools. So quick overview. I know that many of you here are probably familiar on a basic level with what is restorative justice. And when I was researching this, I actually came across a quote from Lynn Riskin that I really liked. And he said, "It's not been made clear to me what restorative justice means exactly." Which, yes, but I'm not sure it's made clear to us, and we've been talking about it half a day, what mediation means exactly. But when people use phrases like restorative justice, they're often referring to, some version of some of these kinds of processes. So restorative conferencing, which is used a lot in New Zealand and Australia, truth and reconciliation commissions in South Africa. And then the two processes that we see the most here in North America, circle work. So you may be familiar with the idea of sitting in a circle and having a talking piece and having a set ritual around how you do the discussion. And then victim offender dialogues, also often called victim offender mediation. All right. I think victim offender mediation is a really interesting piece to look at because that is where it really became popularized in the United States context, at least as near as I can tell. And so this is a quote from the DOJ Office for Victims of Crime. They say, "Restoration of the emotional and material losses resulting from crime is far more important than imposing ever-increasing levels of costly punishment on the offender." And so this idea that this is meant to be a process that deals with emotions in a structured way, but that part of the conversation is necessarily around the emotions of conflict. So when we talk about mediation, we talk about mediation's goals. It's often some principles, some version of this, self-determination, informed consent, neutrality, right? We could have an entire conference where we debate what neutrality means. Confidentiality could be on this list as well. But I think that many of us might agree, although of course we can disagree in the Q&A, that the trend in mediation has been that this is the goal, settlement. Mediation is a process that is used to settle disputes. And this goal has led to a trend in more evaluative styles of mediation, particularly in the court-connected context. And it challenges, I would say, all of these, how self-determined are the results? Is a neutral actually being neutral if they're going to make a proposal at the end of the process? Informed consent, I think we're still doing a pretty good job with that most of the time, at least in testing that the parties actually know what they're agreeing to. Of course, once you get into these quasi-binding processes that have been mentioned, it gets a little bit more difficult. Okay. When you talk about restorative practices, principles like these tend to come up. So notions of accountability for wrongdoing or accountability for the environment, the atmosphere in a place or an institution. Restoration into a community, right? So taking an individual perhaps and bringing them back into a community setting. Repair, right? So if there has been harm done, what can the community do to repair the harm? This could be in the form of dialogue, right? Which would look like victim offender mediation often. It looked like what most of us think of as mediation, where you have a facilitator who's sitting there leading a discussion. And then in a circle, if you're doing something like this in a circle process, there's often a lot more people involved, representatives of the community. If it's a harm circle, the person who's committed the harm, the person who has been harmed. Most restorative practitioners don't actually use victim offender language very much, especially in circles. They'll use language of harm and repair. But one of the things that I worry about is sort of a version of trend towards settlement. Although in my mind, I sort of think of it as a trend towards compliance, right? The notion that restorative practices are somehow meant to cause compliance with a community norm. Right? And I think that that community norm value is really powerful and good a lot of the time. I am concerned, however, that just as we worry about mediation, embedded assumptions of whiteness, I think we're going to see restorative practices, embedded assumptions of whiteness. And I think it's particularly upsetting to see that, right, when so much of the history and tradition of restorative practices comes from indigenous peoples, right? So like circle work is largely a product of Native American First Nations groups in the sort of Canada-US border region. So I'm from Michigan. A lot of the local tribes will use these processes in their own dispute resolution courts and more informally. So the concern I have, go back to this, is that what's going to end up happening is rather than these processes, these practices reflecting actual community values, what is going to happen is they're going to become institutionalized at perhaps a state level or maybe like a local level, but it's not going to be from the affected groups themselves. It's frankly going to be an affluent white person like me who's going to come into a community of color and impose the process. Right? And there have been a number of studies done. There was one recently done in Chicago schools that more or less described just this scenario. It was a school in which a teacher and a group of students had already started doing circle work, and the principal decided, oh, this seems like a great thing. I'm going to bring a professional in, and everything fell apart, right? Because the professional wasn't connected to the community. She didn't do a very good job of listening to the students. It got worse because the teacher who had sort of started them down this path was then let go by the school because of budget cuts, right? And I see this also in terms of poor implementation, right? So in the schools context, for instance, in the Detroit area, which is where I am, there had been a limited number of restorative practitioners that had been provided by the local community mediation centers that went into the schools, but they were essentially being used as compliance officers, right? Their room became the place that you sent kids when they were misbehaving, right? And they weren't actually called upon to do, dialogues, circle processes, the things that they had been trained to do and were frankly volunteering to do. So what do we need to monitor as restorative justice becomes more common? And these, I think, are things that we have already spoken about at length today. Right? How is it being adopted? What sort of processes that fall within this restorative umbrella are being adopted? I think we could say the same thing for mediation, right? Codification. Is it possible to find a way to impose more uniformity, to impose some sort of oversight, right? As these laws and regulations are becoming more common. Implementation difficulties, I've talked about those already. And then finally, this is the big piece. I mean, I think this is why most of us are here today, is to talk about this idea of quality verification. And how do we verify that it's going well? And this is difficult, right? Is it about user satisfaction? Is it about a reduction in recidivism? Is it adherence to agreements that are reached in a restorative process? So what data do we need? Who collects it? And we've heard of a number of researchers today who are doing some of this empirical work in the space of mediation. So Donna Shatosky at Davis, Roselle Whistler at Arizona State is doing a lot of this work. Recently, Ashley Votruba at Nebraska is doing some interesting work around satisfaction in mediation. I do not know, and if you know, please tell me, who's doing this work right now in restorative justice and restorative practices. Okay. So I thought I was going to finish with possibly a lesson from from restorative justice for mediation. So one of the complaints that I hear a lot from people who are primarily mediators talking about restorative practices is that they do not like how scripted most restorative practices are, right? There's sort of a set talking order and a set list of questions that you will often walk participants through. But I also think that that can have a benefit. Because as we've discussed, a lot of the measures of satisfaction are people feeling listened to, right? And less around these notions of getting a better result. But having a more scripted process also cuts down on the facilitator's ability to judge, to evaluate, to impose their own biases into how they direct the process. So I wonder, and I'm just sort of throwing this out here, two things. One, might it be better to have a more scripted approach to mediation so that there actually is less variation in how you might perform what we call mediation, whatever that is. And then I also wonder what the role of artificial intelligence might be. I mean, so artificial intelligence often works, according to scripts. That could be a good thing. That could be a bad thing, of course. And many people are very wary of using AI. But I do wonder, right, if an AI might be able to provide some of this listening, or at least the perception amongst participants of listening, in a way that we could more easily monitor, right? Because we'd have the whole exchange perhaps there to look at and then perhaps analyze using AI. So that's I guess my question for others on the panel. What do you think about that? So thank you very much.
Thank you very much, Professor Archer. Next, we have Art Hinshaw, the John J. Boma Fellow in Alternative Dispute Resolution, the Director of the Lodestar Dispute Resolution Program, and a Clinical Professor of Law at the Sandra Day O'Connor College of Law at Arizona State University. He's co-authored and co-edited 3 books, as well as 25 authored or co-authored articles and book chapters. He's a 3-time winner of the prestigious CPR Awards, including Award for Best Book, Award for Best Professional Article, and Award for Outstanding Professional Achievement. With that.
Hi, it's great to see you. I presume you're gonna come in and change this. While he does that, thank you very much. I also want to thank the people who served lunch today. That was fantastic. I come from Arizona and border areas, and I can verify its tastiness. Right. All right. So my name is Art Henshaw. I come from Arizona State University, where two things are happening at the same time. One, we get the longest titles of anybody in academia. Two, our goal is world domination. We're really good on the titles, not so much on world domination, but we're working on it. And so my presentation is about reasons to hope, reasons to mope. So this is going to be like gunfire going through here. So there are a bunch of things, and kind of like Nancy, and there are times I'm optimistic and there are times I'm really cynical. And so when I get cynical, I always preface the cynical me says this. And when I first came up with this stuff, the cynical me was really verbal. And I decided that I needed to cut it back a little bit because sometimes the cynicism actually is both, right? It can be both at the same time. So don't hold the hopes and mopes too crystallized in your mind as one or the other. So first reason for hope is this, that mediation is the primary process that's being used out there. It's very popular. Nancy has asked the question, why? I don't know that we're answering the question why today, but we're talking around that question. And I want to use one thing that I've worked on that's new data that's not published yet. And so voila, here we are. Thank you, people online. Roselle and I spent some time pre-COVID asking mediators across the country, what's happening in the most recent mediations you're doing? I'm not going to go through everything related to this. We have 4 articles out on it already. This is number 5. And by the way, this is the hardest project I have ever worked on. Trying to track down mediators anywhere is really hard. And so we went through 8 states and we asked questions about settlement. Hey, what kind of settlements are you getting? I have heard all across different numbers. And from these 1,065 mediators, we had, in civil cases, 62% of full settlements in their last mediations. But notice this, do we get the pointer here? Oops, I'm pushing more things at once. So partial agreements we have, provisional agreements. So that means I got an agreement, somebody has to approve it. Oh yeah, I'm gonna be like Ahdieh, aren't I? Your dean. I need to stand here. Partial agreements and no agreements. So 25% had no settlement, family 12%. On those that did not, those are great numbers, by the way, I think. If I were running a court program, I would be pretty excited. The EEOC, Kelly said she had 91%. The EEOC division in Phoenix had 81%. I mean, these numbers are outstanding and staggering when you think about how much time and energy and effort's being saved. So in the no settlement category, look at this, 70% of those in both family and civil were reporting, these are the mediators reporting significant progress towards settlement. So that means probably those ones are going to settle anyway. And that's probably the experience that many of us in this room have had. All right, so why do we mope? And Michael Moffat just told us a big thing about why. And he said that, there are all these great stories out there. Well, let me tell you. These are 2 people who there's a worry about. Now, I have written in detail about this gentleman. Why? Because he spent 18 years in the slammer in Arizona for doing what? For making people think he was a lawyer when he was engaging in mediation practices and telling people, it's going to cost me $5,000 to file this, this document in the courts with you. And people would pay him $5,000. And he wasn't really mediating. He was just taking money. He was a charlatan, like people who work on homes and roofs and stuff like that. He was taking advantage of people. He was trying to date them. He did have sex with some of his clients. And why do we know this? Because he went to jail. That's the regulation system that we have, other than the market, right? The market could say, we're just not going to use these people. But this guy was really, really busy, really busy. Now, this woman, Jennifer Tagliati, I say cautionary tale because she was, I'm gonna put mediator in air quotes, because I think that's her best defense here. Former judge, she was known as the settlement judge in Nevada. And in Nevada, if you had the nastiest case, she's the person you would get to help you out. And so she was the mediator in the 1 October shooting spree. Do you know what that is? Mandalay Bay, the country music festival, and the guy broke out the window and just started shooting. She was one of the 2 mediators in the settlement, right? And you'll never guess who her father was. Her father was the head of security at the hotel when that happened. I'm glad to hear gasps because she mediated that case, and all the lawyers said, we waive it because she's the best, right? And she said, I think I can be neutral, and she may have been fantastic, right? I don't know. All I know is that people who were victims in the shooting have called me and asked me and told me all this kind of stuff. And that's how I found out about her, because I would have known otherwise. And so I wrote a short little article in CPR Alternatives about her saying, right, if a reasonable person thinks that there's an ethical problem here, you shall, right, withdraw. And all the lawyers said, what? That's not the law of Nevada. She can stay. So she stayed and she advertises it. And like I said, she may have done a great job in the work that she did, but it's a question, do people trust it because of who her father was and what he did? And oh, by the way, now she's the commissioner of gaming in Nevada. She's good at rolling the dice, apparently. There's one more case out of Utah that I just found out about a couple of weeks ago, and I'm following it, and it's in litigation. I haven't read it really well, so I can't really put much in it, but I am tracking it to find another cautionary tale. And so Professor Moffitt wants, I can send you the information that I have. All right, so cautionary tales, another place. This is where we can, in official processing, deal with emotional issues. This is the human part, right? Mediation is head and heart. So how do we deal with this kind of stuff? So this seems to be really good. This is what makes it different. This is why the bots will not be able to kill us off entirely until Colin tells us that I'm wrong. So where do we bring this up? So we talk about logos and pathos, emotions, logic. All of negotiation theory that we all study is about the logic part, because negotiation is an emotional activity. And we make mistakes when we do it just purely emotional. People issues versus legal issues. Many of you as mediators know that we start off talking about legal issues, and after a while, they kind of disappear. We stop talking about them, and we talk a lot about the people stuff. And so we're focusing on that. Students are stunned that that's the case. I have students doing EEOC mediations, and they're like, I don't know Title VII very well. And I say, we just need to know the basics, because all this stuff is going to melt away. Just watch. And it does. And we try to work on the person stuff, right? All right. Also, we found, my colleague Roselle and I, that there is some relationship repair reported by mediators in 40% of civil cases. 40%. In family cases, 62%. So some of the things that we've been saying that people might be coming to mediation for, maybe they are coming to that, or at least it can provide some of that. All right, so a reason to mope. Boy, mediation is supposed to be super flexible. Let's do what we need to do for these people. And guess what? That's not what people do. So this gets to routinization, right? And so I'm putting this as a reason to mope, because I've always thought we want this kind of flexibility. Turns out, we asked our mediators, what's the number one thing that determines how you start your mediation, together or apart? And they said, my usual style. That's it. They didn't say the parties need it, and even in family cases, right? And so we're just defaulting to what's easy for us and for the other professionals in the room and what their expectations are. Now, maybe that's a good thing. I've put John Landy up here as in the reason to mope category. Sorry, John. Because he's really been focusing on let's make a system out of this. Let's systematize this. Let's get checklists. That's what they do for surgery. That's what they do for all these professional things, which makes sense. At the same time, when we're doing that, we're losing the flexibility, right? We're just starting to get what's familiar to us and pushing people down those kinds of paths, I think. All right, so if you want to read more about that, it's on the Indisputably blog. Oh, next gen bar exam, woohoo! There is dispute resolution on the next gen bar, and I have to give Professor Nancy Welsh a lot of credit because 10 years ago, I remember you saying, we need to get ADR on the bar. And in my quiet voice, the cynical me said, hell no, that ain't happening. And I was wrong, which is great. Why? Because what we're seeing is those of us who are in legal education, we're working on how do we teach our students differently? How do we examine them differently so they can succeed at the bar exam? And so what's going to be on the bar exam? Client advising and counseling, negotiation, client management. These are things that us in the room have never even thought about as being even possible on a bar exam. So what are they going to do? They're going to give people packets of information like a closed memo. And they're going to say, the question is this, how would you advise your client to handle the situation? Stop. And period. First, I'm going to see what it is their needs are. You know, what's essential to them? What's important? What's just, nice? What's desirable? And then they're going to talk. Anyway, it's going to be big. So we are going to be able to be an important cog of what's coming down the line. And every state will be doing this by 2028. And if they're not doing this, those states will be making up their own bar exam. And I don't think they want to do that. It's really hard to do. All right, so we have these things. A reason to mope. Mediators often view their role very narrowly. Many of us have lamented on this. We didn't really test for this in the study that Roselle and I did, so we can't really say this in an empirically proved kind of way. But anecdotally, in conversations, we see this all the time. And how many of you as mediators have heard this? Yeah, that's nice, but that's not a part of the claim. In the EEOC stuff, we hear it all the time. Why? Because we go to the people issues and try to solve those, try to help people get through whatever those problems are. Okay, reason for hope, but it is a head and a heart process. And AI can do the head. I don't think it can do the heart, but I'm going to be proven wrong momentarily. But here's one thing that I like. AI as a training tool for mediators. So Jean Brett, who was mentioned earlier, contacted me a couple of weeks ago and said, hey, we have this AI process for training mediators. We need beta testers. Would you have your class do this? And I thought, well, this sounds really weird. Are you in those conversations, Colin? Yeah. All right, so Colin's in these conversations. And she said, I'm like, well, how would you do that? She says, bots are the parties. We train the bots to be this way. And there's the great thing. We can have the bots be angry. When you're in class and you get the prompt and it says, you need to be upset. Okay, that's my friend on the other side of the table. And so there are these social norms and pressures. So you can't really be upset, right? In fact, there's a great problem that says, I want you to be upset, but these are the ways to be upset. It describes them, interrupt them, things along those lines. So we can work on trust building. We can work on dealing with angry parties. We can work on all of these things. When do we move into distributive phases? Is it too soon? Is it too late? And we can do it time and time again with the same problem. And we can amp up or lower down where these parties are relative to settlement. So what does it do? It gives, right? We train mediation in the moment, in the moment, in the moment, in the moment. But when we're newbies, when we're novices, we don't even know what to do at all. So we can make a lot of mistakes before we go into our mock situations, right? It'll give us this kind of practice. So I'm gonna be beta testing this a week from yesterday. And Jean said, make sure that everybody knows about this at this conference. So iDecision Games is a great tool. It's a great platform. I use it in my negotiation class. Think about it. So one of the things that she told me is that they're using AI for full-time Alzheimer's caregivers. They don't have time to go to a half-day training, right? And so what do? They use AI with angry family members. Like this is or the angry patient. How do you deal with that? So they type it in. So if somebody's taking a nap, maybe they can get a minute here and work on it. And what they're finding is that they are getting better results dealing with family members on the back end after taking these kinds of training programs. So they're doing pretty good here. And with that, whew, I made it through in 15 minutes. All right.
Thank you very much, Art. Our final speaker will be Colin Rule, who is CEO of Mediate.com. Of course, Colin's been instrumental in building the world of online dispute resolution. He co-founded Online Resolution in 1999, one of the first online dispute resolution providers. Of course, he was director of online dispute resolution for eBay and PayPal. He received the first Frank Sander Award for Innovation in ADR from the American Bar Association in 2020. And I'm also very proud that he is practitioner in residence here at Texas A&M Law School. I've always admired his ability to have a foot in academia and a foot in the real world actually doing stuff. So with that, Colin, Rule.
Well, Peter, I appreciate that, but I readily admits, oh, thanks. I readily admit that I'm a wannabe academic here. That's great. All right, great. Thank you. Yeah, I'm a wannabe academic. I'm not a real academic. Whenever I get an opportunity to teach a class like this weekend at Texas A&M, I say to the students, I am a scab. I'm only here because your university is too cheap to buy you a real professor. So you get a fake professor like me. But
nice.
Yeah. So, there you go. That's what I stand for. That's exactly right. That's exactly right. Every time someone says Professor Rule, so that's okay. So I love the hope and mope framing, Art, and I'm going to adopt that a little bit in mine. I also want to say thanks to all the people. There were so many invocations of the nerdy part of the field, you know, online mediation, online dispute resolution. It is interesting to me. You know, I remember going to the ABA Dispute Resolution Section Conference 20 years ago, and I did a session on ODR. And only 3 people showed up. It was me and Ethan Katch and Dan Rainey, and we're like, well, we already know about this. But now it's fun. We've got a whole sector of the field that's focused on this. So really, and I've said this many times, ODR is just ADR plus technology. It shares all of the same goals, all of the same foundation of practice that we have in ADR. But there's a lot of cool stuff that's happening in ODR. So reason for hope, adopting Art's framing. I think there's a lot of cool stuff that's going on here. Now, there are challenges that emerge, obviously. But I'm going to talk in particular today about artificial intelligence, because that seems to be the hot topic that's on everybody's mind. And I think there are reasons for hope and reasons for mope in terms of AI's integration into the field. So I'm going to start in a weird place. I don't know how many of you expected me to put up a picture of Marie Curie. But does anybody know what Marie is famous for? I know you're lawyers. But, radiation. Yes. What did she discover?
X-rays.
Well, that's true. She did, but that was a sideline. She discovered the element radium, okay, which was the first radioactive element that was ever detected. And this was a huge discovery. It completely changed the world. Everyone was talking about radium and radioactivity. There were articles written about how this was going to completely change the world. It glowed in the dark. And there was actually a cultural moment where people were writing songs about radium. They had Piff, Paff, and Poof, the electrons dancing around. They had, and they actually had radium. They put radium on everything. Radium butter, radium face cream, radium cigarettes. A lot of these things didn't actually have radium in them. It was just a marketing thing, right? And they even had invigorating natural radioactive water from the radium spa. Sounds good, right? Does anyone know why Marie Curie died? Yes.
Poison.
Radiation exposure. They had to bury her in a coffin that was lined with lead because she was so radioactive. And even her notes that she had in her lab in Paris, they had to put in lead boxes because it was so toxic. No one understood that this was incredibly. Now, of course, radioactivity turned out to be a very important thing. I mean, we have our nuclear powered submarines, we have nuclear energy. There's a lot of things that came out of it, but it glowed in the dark, right? If you mixed it with luminous paint. So they would put radium, little bits of radioactive into the paint that they would use to paint the clock faces. And these women that painted the numbers, they had to have points on the paintbrushes. So they would dip it in the paint and then lick the brushes in order to paint the numbers. So people had no idea how toxic this was going to be. Now, why do I raise this? I know I have limited time. I'm raising this because this is where we are with AI. It's almost the exact same thing. And people are writing songs about AI. It's in our art. It's completely infiltrated the entire cultural conversation about where we are going, almost as a species. And I think the interesting thing about this is it's kind of a Rorschach test. I think what you see when you look at AI has less to do with AI and more to do about you. And whenever I ask my students about AI, I say, what movie do you think about? What's the #1 movie people think about when they think about AI? Terminator, exactly. Skynet, right? And I actually have friends at Google who are working on the DeepMind team, and they're worried that the AI, once it takes over, artificial and general intelligence, is going to side with the ants. Okay, because there's more ants than there are people, both by weight and by count. And they may take a look at the values of the people and all the mess that they're making of things and look at the ants and say, I think the ants got it figured out. So the AI is just going to team with the ants. Now, whether or not that makes a bunch of robot Arnold Schwarzeneggers to come murder all of us, I don't know, I guess. TBD. But I actually think this dystopian vision is not the best movie that indicates where we're going. The movie that does, I think, the best job is this movie. Does anybody know what movie this is? WALL-E, right? Okay, so the Earth turns into just a slag heap, and all the humans migrate up to spaceships floating over the planet. And the AIs put us in floating chairs and play us funny videos and bring us milkshakes and just kind of keep us out of the way, right? Because they're kind of running the show. They know really how things work. So this, to me, I think amusing ourselves to death is a much greater threat than the robot Arnold Schwarzeneggers. But the point is, we in ODR, we don't talk about AI. You know, AI means a lot of different things to a lot of different people. I did a presentation in Israel in front of a bunch of computer scientists. And I put up my first slide and I said, AI and dispute resolution. And one of them raised their hand and said, what is AI? And these are all like computer scientists. And I'm like, uh-oh, I'm in trouble. Isn't it machine learning? And he said, no, AI is not machine learning. And someone else said, yes, it is machine learning. And then they just had an argument for the next 30 minutes. And I was like, okay, I'll just back away slowly. AI is a term of art. It means a lot of different things. But in the online dispute resolution field, we talk about technology as the fourth party, okay? Party 1 and party 2 are the disputants. Party 3 is the human neutral. Technology has a seat at the table. And I put up this happy little robot because it's much less threatening than Arnold Schwarzenegger and Skynet. Because if technology has a seat at the table, we can ask it to help us. The third party and the fourth party are partners. And there's a lot of stuff that we ask the fourth party to do today that's not controversial at all. Intake, diagnosis, administration, payments, document management, calendars. Does anyone remember the old days when you had to call up the party? What about Wednesday at 1? Okay, that works. You call the other one Wednesday at 1. No, I can't do that. How about Thursday at 2? Now you just send them a doodle. It's done. Okay. This is not controversial anymore. The question is, where are we going? What is this technology going to be able to do 5 years, 10 years down the road? It's less about what the tools can do today and more about the arrows, what direction they're pointing us in. And things like research case evaluation, reframing, coaching, BATNAs and WATNAs, enforcement, document drafting, and even this idea of agents taking the information and going off and negotiating the case on their own and coming back and saying, hey, I got you 80% of your money. Is that good enough? No, that's not good enough. Go get me more. And that agent is probably negotiating against other agents, okay? This stuff all sounds like science fiction, but all of this stuff sounded like science fiction 20 years ago, and now it's commonplace. So the point I want to make is also, I'm not going to get into the specifics of how AI works, but essentially you take a lot of data and you have a computer analyze it, and it comes up with a set of correlations, patterns in the data. If any of you use Gmail and you start typing a sentence and then it completes the sentence for you, I'm sure I've had this experience where I'm typing something and it gives me a suggestion. And I'm like, no, I don't need a suggestion. And then I read it and I go, oh yeah, that's better. That's better. Yeah, I'll just take the suggestion. Essentially, that's what an LLM is. It is predicting the next word in a series and it's called neural networks. It's a kind of AI. So it's analyzed the entire internet, petabytes of data, and distilled it down to a set of correlations. So there is a real risk, and we've talked about this today, about bias making its way into these data sets. If you have biased data and you train an AI, it will execute that bias. But the good news is it's data, and you can do things to de-bias that data. Whereas bias in human-powered systems is much harder to identify and combat. But there's a lot of good research that's happening, and this is a reason for MOPE, is making sure we get this right. AI is going to kick up a lot of dust very quickly. And the goal is for us to civilize this technology and create the guardrails to minimize the negative aspects of it like this, and make sure that it helps us achieve our long-term objectives. So everyone's talking about Claude and Gemini and ChatGPT. These are the big companies that are building these tools. But what's exciting to me, actually, one of my students at Stanford created this website, Hugging Face, which is kind of for nerds, but it's for all the open source AIs. And you can download, well, you can't really see this, but there's software where you can download these models and run it locally on your computer. And I'm telling you, within 3-4 years, you're going to be running AIs on your computer and on your watch and on your phone and on your refrigerator. And they're all going to be based on different training sets, and you're going to be asking those AIs to perform different tasks. So it's not just a matter of Google and all these guys building these tools, and then it's one AI to rule them all. There's going to be thousands and thousands of AIs, and we are going to build our own AIs. And the way we're going to do that is through something called RAG LLMs. And RAG stands for Retrieval Augmented Generation. Okay, I'm going too fast here. Okay, there we go. So this is where you get an AI. Oh, I went too fast. You get an AI and you feed it your data, you train it, much like an assistant. The way to think about these LLMs is they're an eager assistant that is next to you, and you can ask it to do anything. Having an AI is a little bit like having a magic lamp. You know, the genie is not what's dangerous, it's the wisher. So we have to get really good at wishing. We've all read The Monkey's Paw, where you have unintended consequences of what you ask for. Our goal now, we're not going to be necessarily the creator, but we're the ones who come up with the idea of what needs to be created. So if we can train these AIs using documents that get all chunked up and put into these vector databases and educate the AIs, that's where the rubber hits the road. And that's when the problem of hallucinations is significantly reduced. So I'm not going to talk about the technology, but you can log into ChatGPT today and you can build your own RAG AI. And actually, this is what Art was just talking about. Hero and I at UC Law have trained up, bots to do negotiations. You give it the negotiation simulation and say, you play the other side, or you play the parties, I'll be the mediator. And it has all the details and it just clicks right into the role. So we've done that all in ChatGPT. So anybody can do this. It's a no-code solution. And then you get a link and you can share it with as many people as you like. So this is where it's going. It's not going to be OpenAI telling us what to do. It's going to be us building our assistants and customizing it with the knowledge that we have. So there's a lot of potential for this technology in dispute resolution. If you think about natural language intake, if you think about summarizing enormous amounts of information, if you think about document generation, like creating draft settlement agreements, or assisting panelist search so you can find the right neutral to fit a particular case. And then tone monitoring is very interesting too. It's almost like Grammarly for conflict resolution, where you nudge the parties towards communication styles that are going to increase the likelihood of resolution. But the holy grail is this idea of an AI mediator or an AI ombudsperson or an AI arbitrator. And again, we're not going to get there overnight. I think it's going to take a lot of time for us to train and refine these models to get them where they need to go. But when it comes to the hope aspect of this, it's going to open the door to access to justice for many, many people. All these pro se litigants that can't afford representation, they can't figure out where to begin their justice journey. This is going to create many more opportunities for that. Because the point of access to justice is not going to be some courthouse downtown. It's going to be here. It's going to be here. And whenever that issue arises, you can click a button and initiate this process and get put on the right path. Okay, so I'm not going to go through this example here, but I will put up this last picture and then we can get into the discussion. It's really, okay, pokey. This is a platform I'm showing you where you can upload all the information in your case. You can engage in a dialogue back and forth, and that the AI will then tell you what the strengths of your case is, what the weakness of your case is, ask all the key questions, and you can ask it to provide an evaluative outcome. And this is running today. So I wouldn't put parties directly into a platform like that, but we need to be aware that this technology is there and it's being refined right in front of our eyes. Okay. So the other thing is we have to come up with ethical standards for the use of this technology. And this organization that I'm involved with, ICODER, the International Council for Online Dispute Resolution, we've created these ethical standards and they're all optimized around AI. And if you go to icoder.org, we translate into 15 languages. And there's a lot of standards of practice for how we can address this. But one of the things in the field is a lot of our ethical standards presume we're talking to mediators and arbitrators. But we need to now come up with ethical standards for platform designers. Because if algorithms are going to be playing a greater role in our processes, we need to come up with ethical rules and processes through which we can guarantee that the algorithms we use abide by ethical standards that are in line with what we think are best practices in the field. So, okay, I'm not going to go through these either. The point I wanted to make, let me just go through go to the last slide here. See if I can do it this way. Maybe, maybe not. No, well, it doesn't like it, but I'll click through this way. The point I want to make is the fourth party is here to stay. And I think that we are going to need to learn to operate with the fourth party. We don't need to, the fear that people have is that AI is going to replace them. Okay, come on, how many ethical dilemmas do I have? Here we go. The fear is that AI is going to replace mediators. And I actually think that's not true. I think Art made this point too. It's going to enable us to be more human. We're going to shift more of these administrative responsibilities onto technology, and we're going to need to focus on the emotional journey, the psychological journey of our disputes. And hopefully it's going to give us more time to focus on the pieces that make us more essential. But I think that sitting alongside the fourth party at the table is a huge reason for optimism for us. And it's not about where we are today, it's about where we're going. And I think the continual learning of these processes and our joint refinement of these tools will help us achieve our objectives as a field. And that's a big reason for optimism. So I'll leave it there. Thank you very much.
All right, why don't we have all the panelists come up here? And if I could just maybe just throw out the first question to get us started. So we're the look to the future panel, right? So I just want to say, I love coming to this symposium because I usually see some of my former students. And so this morning I walked in and lo and behold, there's a former student who I had in about 2015. And we were both sort of saying, oh, you know, with mediation, I don't know if I really like the direction that it's going with this virtual stuff. And we both kind of commiserated like, yeah, I really like in-person mediation. So, and then I was just amazed to find out Jim Alfini reported, right, it's really going in that direction to a far greater extent than I was even aware. I mean, when he said his son did 20 mediations and only one was in person, and then some of the platforms are making their, you know, that they automatically go virtual, but you have to request doing it in person. And then Michael Calatrava tells us that, you know, they're doing surveys, settlement rates are as high or higher than in person, satisfaction rates are as high or higher than in person. So in many respects, I mean, just looking at this from, you know, miles high, at this point, looking at that, that's the future. The future's already here. That's the future of mediation. And in some ways, that gives me more hope than hope. And I want to know how the panelists respond to that.
Well, I think it's an accurate observation, right? So that a lot of mediation, if not the majority of it, has moved online, and I think that's where it's going to stay. And we were talking earlier about why that is. Is it about cost efficiency? Is it about timing? I think it's all of those things. We're also seeing court systems moving online too. So, I mean, there's sort of that piece to think about. I actually see this as hopeful. And so one thing that I think about is the increasing prevalence of shuttle mediation in sort of anything business or commercial. The parties, they're just like, I want to be in separate rooms. I don't want to see the other person. And I find that the online platform actually makes it a little bit easier to do joint session work because it's very easy to do breakout rooms. Like if you need a breakout room, you have the breakout room. But the flip side is true as well. You know, it's very easy to have people in the same virtual room together. But something about being virtual, I think, cuts a little bit of the perceived tension that people are trying to avoid, you know, thus asking for shuttle. Of course, there's a lot of things that you don't communicate virtually that you do in person.
That's true. That's the one thing. So you think about the nonverbals. The nonverbals are mediated through whatever device you happen to have. So you know, this conversation about the phone. My wife is a judge and she conducts online hearings all the time. She is the IT specialist of the courtroom, working with people on this all the time. Try this, try this, try that, try the other thing. But I think I don't think it's a problem. And one of the things, in fact, when you were on that panel with Gretchen Witchmer for ASU in January, she was talking, and she's the head of the AAA, former Supreme Court judge of Michigan. And she said that she was, I'm gonna say gobsmacked.
Bridget McCormick.
Bridget,
Oh,
yeah.
sorry.
It's all good.
Gretchen Whitmer. Cool.
That's what Emeritus.
Gretchen Whitmer is Michigan's
McCormick.
governor, but
Yeah, I get it.
yeah.
Bridget.
Bridget McCormick, yep.
I am so sorry. If you're watching, I apologize.
I think they would actually both be flattered by the comparison.
Okay, yeah, I'm glad to hear that. I'm really good at getting people mixed up. But the idea was, man, we did this pivot online really quickly. Courtrooms changed. We mediators changed. We mediators stayed. Courts are going back and have gone back. And she was gobsmacked because she said there are so fewer default judgments now. People are able to do everything. And this is what Cynthia was talking about a little bit earlier. This access to justice thing is real, and that's what courts are about. And we are, I'm just gonna say, we are conflict specialists. And where is the professional space for conflict resolution, conflict? It's the court system, right? That's where it is. That's where it's legitimized. We go to these places when we can't figure it out on our own. And so we're actually paving the way for the courts and normalizing it that much more. So I think it's something for us to be all right with. Granted, the nonverbals are still going to be down, right? And how much of our communication is nonverbal? A bunch, more than our verbal, but we still get some of that nonverbal come through with tone of voice. We see people react, and mediators always like, I saw you squirm when I said that. Why did you squirm? We're going to keep doing some of that stuff.
Yeah, I mean, it's very interesting the degree to which technology, obviously, mediation is transforming technology. We're building new tools, we're refining tools, but technology is transforming mediation as well. And as you say, I think the pandemic, it rang a bell that can't be unrung. I certainly had mediators that are heroes of mine, that I really look to as, paragons of the practice, who told me for years, you can't do this work online. You've got to be face to face. You got to see the tapping foot. You got to smell the pheromones. And then, okay, pandemic, and some of them tried to do mediation in person where you're separated by 6 feet with a mask, and they're like, this is no good. So, and then they tried Zoom, and, everybody kind of had to set up your little corner of the house with the lighting and the camera and all that stuff. And now those people say to me, I love it. I default to it. I prefer it. Because the first article I ever wrote on media.com in 2000 was new mediator capabilities in online dispute resolution. And some of it hasn't aged that well. But it's an amazing thing to be able to see all the faces at one time. So someone is talking and you can look at the face of the person listening, which is not a norm face to face. You can't really look at the person who's listening because that's creepy. Another thing is there's noise cancellation technology in Zoom. So there's very little overtalk, because if people overtalk, everything cuts out and no one can understand anything that people say. So people don't even realize this, but a lot of what mediators do face to face is they say, okay, wait your turn. This is uninterrupted storytelling. You'll get your chance. Online, the technology does that for you. Parties know that that's a norm. There's very little overtalk. So I'm not saying that it's better across the board. Actually, the satisfaction numbers are often a little bit higher for face-to-face than for online mediation. But the preference numbers are off the charts due to convenience. What we found is when we launch ODR in courts, 85% of the resolutions we deliver happen at a time when the court is closed for business. So that's late on a weekday or the weekends. So that's a huge access to justice issue right there. If we're only opening the courts at times when people are working, that's an obstacle. And that's why we have a lot of these default judgments. Yeah. So I'm not saying, I can sometimes come off as a cheerleader for this technology. I think there's a lot of challenges we have to address. But it's interesting to me that this is now this is the new normal. Online mediation is the new normal, and face-to-face is the alternative. And I don't think we're ever going to go back to the way we were. Yeah.
So I'm curious, Colin talked about one of the advantages of the AI is that it's going to give us more time and space to deal with the emotional side of things, because we'll clear out the administrative kind of busy work that we all get sucked into. But I'm curious how that aligns with what we've seen happening in the development of mediation, where so much of what is the driver, and we've seen it in many of the talks today, has been about money. and about efficiency. And a lot of the concerns that come out, I'm thinking of Aaron and restorative justice and Bright talking about the McDonaldization of restorative justice, right? These concerns that when we're using these processes in more to save money for efficiency, to just get things taken care of, we're not taking care of the emotional side of things, and AI seems to more support those kinds of approaches. So I'm just curious if all the panelists, because you've all talked about it in different ways, what your reactions and thoughts are to that.
Well, I think at the end of my talk, I sort of made a nod that there might be ways in which AI can be useful. And I do think that one of the problems we have is data. And I do wonder that, you know, when you have an AI database that is presumably gathering all this data, what can it be telling us about the process? I also think that, you know, when we're talking about the question of what is mediation, I think the increasingly evaluative form of mediation, maybe some of that could go into an AI process and people would be just as satisfied with that. And I won't go on my tangent about Michigan mediation, which is case evaluation. But if anybody wants to ask me about that later, I'd be happy to talk. I think the thing that I'm worried about is that there are often disputes that either the parties or the lawyers think are just about money, when really it is about emotions, and they would benefit from walking through those things with a neutral. And I worry that those kinds of disputes are going to get ignored and they're just going to say, oh, money dispute, put it through the computer.
Well, I will say I've spent now 20 years selling ODR. And the reason why 95% of my customers say yes is cost savings and efficiency. That's true for courts, that's true for businesses. But I like to think I'm slipping a little quality in there too. You know? I mean, like, I think, you know, but I think that's true face-to-face mediation too. I think a lot of people say, well, it takes less time, takes less resources. You know, if we can get 60 to 80% resolutions, like Art's talking about, those are good numbers. But what is it that's motivating people to make change? And that's just not just online dispute resolution, that's all technology. There's a guy in Silicon Valley, a guy named Mark Andreessen, who runs a big investment firm, and he wrote an article 10 years ago that said software is going to eat the world. And you know what? It happened. Software ate the world. It's very hard to find any corner of our society where software hasn't, you know, insinuated itself into those operations. And why is it that every single industry has adopted this technology? Efficiency and cost savings. That's really fundamentally what's driving the change. But that doesn't necessarily mean, you know, efficiency. I have a friend, Ben Barton, who's a professor at the University of Tennessee. And he wrote a book called Glass Half Full. And one of the things he said is, let's use all of this ODR technology on the civil side. Let's make it as efficient as possible. Let's reduce time to decision. Let's get efficient resolutions and save a big chunk of money. And then let's put all of it in the criminal side, because we are not living up to our procedural, and that's life and death. So don't take a dollar out of the justice system. Let's just realize these efficiencies and let's reallocate it. And I think that a lot of the motivations people have in achieving this efficiency is not necessarily, oh, I just want to put more money in my pocket. It's that we want to better balance the objectives we have as an organization. So if we can figure out a way to utilize these tools to realize that efficiency, but also realize a quality improvement, you know, last comment, then I'll hand it to Art. One of my good friends is a guy named Richard Susskind, who's the chief IT advisor to the Lord Chief Justice in the UK. And he wrote a book called Online Courts in the Future of Justice. And one of the things he observes in that book is about 50% of the people on the planet do not have meaningful access to a justice system. So if you have the system the way we currently designed it, and you say, okay, we're going to put, I don't know, how are we going to get to 55% around the planet? It's very, very difficult to imagine how you can do that with the system that we currently have. But if we utilize all these tools and we can be creative, well, then maybe this is an opportunity for us to increase access to justice on a step function basis. I mean, that could radically change the quality of lives on a utilitarian basis around the world. But we have to be creative. We have to rethink these systems. Because the justice system, the one that we have right now, was designed 100 years ago. And it's based on the coercive power of the nation state. And it's based on judges and jails and courts and geographic laws. And that's not the world that we're moving into. We have to think about where all of this is headed. The internet doesn't care about states versus, or Canada versus US or US versus China. It's like, it's a borderless, always on world. So shouldn't we build a justice system that works the way the internet works to handle those kinds of cases? So again, we have to be very creative. It's not like these problems are going to solve themselves. But I think it's an exciting systems design opportunity for us to make a better system. And we bring the stuff from the legacy system we like, but then we use the new tools to build something that achieves our objectives on a more effective level.
All right, now I'm gonna say this, and I truly believe it. This would never work. I can remember being asked to do online training programs in like 2002, things like that, or, distance learning. I was like, it will never work. I'm not doing it. Stop. End of sentence. And of course, we know where we are today. So as you can see, I'm really good at predicting the future. Just ask me which celebrities are gonna break up and divorce, I'll tell you. So the thing that I am really deeply a firm believer of is that people have to go through mental processing to get to the place where they need to be when they can say, okay, I can live with that, right? Because really, what are we getting to? We are getting to can live with. That's what our goal is. I can live with that. And that is a mental process that takes time. And the time that we need is not that AI figuring it out, right? What was it that you all said that ChatGPT did the bar exam this past year in 6 minutes?
Yes.
And got a top 10% score, right? 6 minutes. We can't compete with 6 minutes. The answer is going to be there. There's a guy in Phoenix who used to work for Intel. His name's Bob Bergman. And he has come up with ways to figure out what the numbers should be. He's a decision-making scientist. He's retired from Intel. This is what he does. This is how he keeps himself busy. I saw an early iteration of this. And the whole time I just kept thinking, great, you can get the decision, but how are you going to get the people there? And that's what our job is going to be. Our job is going to be getting the people there. That's what it is. And we're going to be able to come up with the numbers pretty easy. And so this is where I do believe the next gen bar helps our field, because now the lawyers are going to start learning more about this, learning more about the ways that humans act in conflict. And they're not going to all say, they're just greedy. Oh, my client's just a greedy bastard, right? They're going to understand, hopefully, at least a little bit about what it takes for people to get to where they need so they can say, I can live with that.
One of you.
You discussed earlier how mediation is not really known well to the general public. And it's frequently connected to having a legal field or a legal administrator. And so when we think about ODR and how it's viewed and its legitimacy, if people are already very skeptical of maybe the dispute resolution processes that were available, or they only saw mediation as something that you can get, if you can also get someone who has 7 years of education, how do you make them feel that this online option isn't just a cheap form, or it's still not a legitimate source of resolution, since it is also still built by the same groups or demographics that they didn't feel like they could get justice from before?
Yeah, I can respond to that. When I was at eBay, it was interesting because I was working with non-dispute resolution people, and all of our parties didn't know anything about dispute resolution. So we had something called the User Experience Lab, and we would buy people pizza and give them $100 and they could come in and we would test them. We'd put them through all these prototypes. So one of the things I did was I tested all the language in dispute resolution, right? So the first thing is everybody thinks mediation is meditation. Okay. The second thing is the closest association people have with resolution is New Year's. Okay. So people say, oh, why do I need a resolution? Why do I need to lose weight? And even lawyers, I talk to a lot of lawyers and they're a little unclear on the difference between arbitration and mediation. Maybe the new next gen bar is going to help with that. But the point is the language we use within our communities to describe all of this stuff is alienating to the people we're trying to help. And even the word dispute was hated at eBay. We tested it across thousands of people. And they said it implies a certain amount of like moral failure. Like I have a disagreement with the other side. It's like, look, I bought an item and it never showed up. How's that a dispute? Like, and I would often go to property tax assessors and I would say, how many disputes do you have? They say, oh, no disputes, because they're an elected official. They don't want to have disputes with their citizens. And I say, okay, well, how many appeals do you have? Oh, we have 16,000. It's like, okay, well, we'll call it an appeal. But the thing is, we have to talk to our language. This has to be human-centered design. This is not about us. It's not about court administrators and mediators and law professors saying, what language do we think accurately describes this? It's about what is the language that's most going to resonate with the people we're trying to help. So what we found at eBay was problem solution. I have a problem, I need a solution. That doesn't imply any moral failure. We say problems are inevitable. I bought an item, it didn't show up. Okay, it's a problem. It's not necessarily a dispute. You're not disagreeing with the other side. Maybe the post office dropped it off next door. Maybe a porch pirate took it. Who knows what happened? But the problem, if you have a problem, we need to find a solution. So I think your point is very well taken. I think sometimes we're a little bit too, we're too inward focused in trying to describe what it is. And I think, you know, we can use the word mediation internally in the field, but we need to figure out what language is going to work for the people that we're actually trying to help. And there may be a better framework that will be an evolution of our practice that will, you know, people have always said to me, 30 years in the field, if only we had one Super Bowl ad, you know, we could market it and then everybody would understand what it is. It's like, that is not going to work. 30 seconds is not going to work. It doesn't even matter who your pitch man is. So this is something we have to be more open to in the field. So.
Professor Gunning, and this will probably be the last question. I think we want to end at 3, is that correct? So Professor Gunning, I think you get the last question.
What's my question? I guess I wanna ask you, I mean, I take your point, Colin, that I can't be a Luddite and I can't just say, I wanna stop this AI stuff. It is all about Arnold and the Terminator. But I'm really concerned when you kind of breeze by, oh, we can debias it. Can we?
Yeah.
I mean, what is the work that we need to do? I don't hear enough. I mean, if I go on and look at Joy Walimi, I can't pronounce her last name, but she talks about how, you know, there are Black men getting arrested because the AI stuff that does, you know, facial recognition can't see us. There are Black people who are using medical devices that don't work for them because they never tested it on darker skin, right? I mean, and I heard about that years ago. And now it's just hitting like the LA Times. How are we, you know, the idea of we're collecting data off the internet. I mean, I don't understand all of it, but I hear the stories about who was it that tried to have an AI, you know, a young AI person, you know, just learn how to talk. And within a couple of hours, they had to yank them off because they were talking about kill Jews and, you know.
They had a bunch of Nazis come in and train it on all anti-Semitic stuff. Yeah.
So I want to hear more. I know we've got to do something.
Absolutely.
Right? But I need to hear a lot more. And I feel like I don't hear enough when people talk about this on really what's going to be the debias work. Because it's not, you know, we could still be in a situation where folks of color, marginalized folks, working class folks,
right?
You know, yeah, they get to a point out where they say, I guess I can do this, but it's like really not good for them.
Totally.
And we could have thought through that if we thought, so anyway.
No, let me underscore the point. I mean, again, remember at the beginning of the internet, I remember in the late 90s when the internet was coming up, it was, this is going to be amazing. It's going to be wonderful for the world and everyone's going to have access to information. It's going to level the playing field. You know, it didn't really turn out that way, you know, and we always had this techno optimism at the beginning. It's sort of the rosy scenario that happened with e-commerce, that happened with social networking. And now we know what that looks like. Okay, so let me paint a slightly more dystopian picture, right? What if we build all this technology and then we just aim it at the pro se litigants, the low income people, right? Well, you can't afford a lawyer, so you got to go into the automated path, right? And then nobody's paying attention to it. Nobody's monitoring the outcomes. And then it's just like Charlie Chaplin in the machine, you know, the gears are like grinding people up. And it's like, you know, if you're rich, you get the human powered process with white glove. And those folks, you know, you can file a motion here, extend this, and, you know, eventually they'll just drop it. Whereas the people who have to go through the automated process, you know, like it's not a justice system. And I think that there is a real risk that we're going to build that two-tier system. Yeah. If that happens, we fail. And let me be clear, you know, Tim Gebru and Joy and people who are really looking at this question, we have to ask hard questions. And if you look at some of these big companies like Google, they have a terrible record on this.
Yes.
Because the people that are talking about AI ethics and asking these hard questions, they start to put pressure on the organization and there's billions at stake. So they eject those people. It's like, you know, you're slowing us down, you're making us look bad. So there are many, many sand traps that we can step into. One of the things that I'm proud of in the dispute resolution field is we don't have any ODR billionaires, right? We don't have outsiders that have come in and built some kangaroo court and then taken all the cases. I think we've done it much more slowly and deliberately, and I think we've put ethics in. And we're not the early adopters, you know, we are second, third wave adopters because we really want to ask these questions and think about it. But that's not to say that there isn't going to be some opportunist that is going to come in and build a kangaroo court and then, you know, suck all of the volume away. So we have to ask these hard questions. I do think that, and I talk in much more depth about bias in AI, but human powered justice systems are biased. We know people of color get 30% worse outcomes from the courts. This has been true for decades. And people have tried and tried and tried to fix this problem. But where does it live? It lives in the implicit bias that's in the humans that are administering the process. It's very difficult to put your finger on it. And if you go talk to people and say, wait, are you racist? I'm not racist. I don't have any bias at all. But who knows? The systems persist. I have optimism that when we get it into data, and there's a lot of data scientists that have worked on this, you can find the data, you can find the bias, and you can de-bias those data sets. And it's not just a black box where you have to evaluate the outcomes and say, is that good or is that bad? You can actually go in and it shows it work. It shows its work. And you can see where these things happen. So I remain glass half full on this, but I hear you 100%. And if you look at the past experience where capitalism has taken optimistic new technologies and grounded into pessimism and greed, that's going to happen here too. But if we set the guardrails and we insist in our world, these are the terms upon which this technology could be deployed, I think we can eventually figure out how to use these tools to do better than we're currently doing.
I mean, to your point, Colin, though, I'm very concerned about a regime in which people self-regulate this.
Yes.
I mean, because, you know, the story with Google and Timney, you know, she looked at the data. She's a data scientist.
Right.
She told them what the data said and she was out. So I don't think it can be something where we rely on the AI creators themselves to be doing this kind
Well,
of.
the interesting thing, Gemini just had this issue with image generation where somebody said, well, we want to have, you know, racial balance. And then people would say, show me a picture of the founding fathers. And they were all African-American. So then the Twitterverse, the Elon guys lost their minds. See, it's woke, it's woke. So we're going to have wars about this back and forth because you got to figure out how to thread the needle. I mean, the other thing, I have a lot of friends in Nigeria and they're using these LLMs. And if you ask, you know, Dolly, show me a picture of lawyers chatting, 90% it's going to be all white.
Oh, absolutely.
You know, but if you're in Lagos, show me a picture of lawyers chatting, they should all be Nigerian. So that's why we need to let 1,000 flowers bloom. We got to be building lots and lots of these AIs. And they got to be trained by different people because that's where the balance comes from. It's not that one's going to get it right. Please.
And this is where regulation comes in, and we have none of it.
On that high note.
That's
Move to our next. Thanks very much to our panel.
Or anything that you heard today that is revelatory for you, that reveals something about what it is, what mediation is today.
It's great to know I'm not gonna get sued.
It's good to know you're not gonna get sick.
That's what you took from it.
Well, and let me just say, one of the questions, since I said I was gonna sprinkle in the questions where I thought they fit. One of the questions or comments that came up was basically saying, why does a bar association have any role at all in the practice of mediators who are not lawyers? And I think the answer is pretty straightforwardly, well, unauthorized practice of law is still something that can be pursued. It's not as though you are being subject to discipline as a member of the bar, but UPL is something that can come up. But I think you had actually raised the example of mediators who were not lawyers having problems with the Bar Association after more lawyers started to become mediators. Anything that you want to add in connection with what role appropriately or inappropriately the bar has in connection with mediators who are not lawyers?
Well, I just remember in those early days in the late 1980s, early 1990s, that there were some excellent mediators. I'm thinking of some that were like architectural field, engineering, in the counseling and psychological field, what wonderful mediators they were. They were not lawyers.
Yeah.
And how we as lawyers, I mean, I'm talking about my own profession now, we tend to be kind of control freaks. And we want to control communication. We don't want to necessarily facilitate it.
Yeah.
And so I was kind of sad when I saw that schism, when I saw that split.
Yeah.
When really they were kind of shoved aside by the bar.
Yeah.
Some of them were leaders in the ADR movement before the bar really got on board.
Yeah.
But I must say, I have to say this also, sitting here today, that I'm thrilled. I mean, because in the late 1980s, we were talking about, could this ever be part of our legal system? Will it be accepted? The ADR Act took 3 times before it was passed.
Yeah.
And so in those days,
Know that.
yes,
Okay.
in those days, we were like, is this plane at Kitty Hawk ever gonna get off the ground? And now we're talking about problems landing on the moon practically with ADR and mediation. So it's exciting to see how much it has developed over the last 4 decades.
Great, thank you for that. Yeah.
Answer your first question, Professor Henshaw. You said something I thought that was important. The mediators in your the sample, yes, that you did, thank you. About that's the way I do it, you know, whether I'm caucusing or not caucusing, or this is how I'm gonna do the mediation. This is how I usually do it. I'm not gonna listen to anybody. I'm not gonna, I'm not gonna see what even the situation is about. I'm just, you're in 2 rooms, y'all go that way, I'll decide, you know. But that was just so prevalent in mediations that I coordinate with Tarrant County. But I've seen and there's the Zoom part, everybody talking about that can't possibly be, it works. I've seen it work and work and work. And sometimes I do mediations in person, I do mediations in Zoom. And I even had an attorney the other day, just this week, I have my hand on the door. I'm bringing the husband in with the wife. Okay, it's his client. The mom inside is pro se. The mediator's in the room. My hand's on the door. He goes, "Wait, are we going in the same room?" And I was like, "Yes." Okay, yes, we are. It was a 4-hour mediation. Toward the end of the mediation, the wife said, "Can I have him in the room? I'd like to talk with him."
Wow.
And had he have been in the room, that mediation wouldn't have lasted 4 hours. Would have lasted maybe 2. And once they started talking, things settled. We had already crossed the box, not settled. Okay, and when he walked in the room, so I was just like, I mean, if people, you know, the attorney is the one that did it. He said, "No, we're not going in there. I don't want." He was protecting his client. I understand, but if they had been in the same room, and I've had mediators say, "I want everyone to stay in the same room, no matter what." You know, and sometimes that's good, sometimes it's not. You got to read the room.
Yeah.
That's all I'm saying.
Yeah, so we need to respond to what the parties need as opposed to assuming there is one right way to do this. Okay, well, you know, because you run a program, another question that was asked, arose. Well, the question was, what about if the mediator does a bad job and does not want to have feedback? Because we were talking about how there really is a need for mediators to get feedback regarding how they've done. So what about if the mediator does a bad job and doesn't want feedback? The mediator knows everything and is not welcome to feedback. How do you handle this from there? And those of you who run programs or are part of programs, I wonder whether you might have any thoughts on that.
I think Janet did a really good job of talking to people about when there was a problem, because you get problem calls, you get the feedback from clients, and she always did a really good job with saying, this is a teaching moment. Please don't look at it any other way. Don't be offended. This is a teaching moment.
Learn from it. Yes.
I designed a mediation program at the University of North Texas, and I've also been involved with Judge Swearingen's in-court mediation program. Every good program that I've been involved with has a survey at the end, brief, to give feedback to the mediation program and to the mediator. I think it's essential.
Yeah. Okay, back to the main program here. So, is there anything anyone wants to talk about in terms of, besides the fact that it's very unlikely that you'll get sued, or if you're sued, it's very, very, very extremely extraordinarily unlikely that you would be found liable. Anything, else anyone wants to talk about in connection with how mediation is institutionalized today? Okay, so let me go to the next question. Given what you've heard today, what would you say that mediation and that mediators reliably, maybe not always, but reliably provide to the parties? How would you describe that, Michael?
I would say presence, and this was something that Kelly talked about, and that I actually truly believe in when I talk about in my mediation class, is that simply having a third party in the room, people behave better by and large. And so there's a certain number of mediations that I've seen or done where the mediator is, giving a process, they have their opening or whatever, but what they really bring is sort of a presence to the room that parties will behave more civilly and communicate better than they would if there wasn't there. And I think we shouldn't dismiss that because we're not using our fancy tools or fancy theories, that you're bringing something to that process, even if you don't do all those things that they wouldn't have, but for the fact that you're there. And so I think mediators, then probably one of the most important things is they reliably bring their presence to the room.
So I'm gonna, it looks like others are willing to step up. Go ahead, Kelly.
Well, I agree with Michael. I also want to say what I wrote when I was thinking about this, and I think it was emphasized all day, was it's a way to exchange information, which can be negative and positive, right? But it is an opportunity to share information in ways that they haven't before.
Okay.
And one of the things, when I talk to the students and you say, why do we repeat so much? And it's because they've stopped listening to each other, or they wouldn't necessarily be here. And so I think it's an opportunity to exchange information in a way people may not have been able to hear it before.
Okay, great. Isabel?
Yeah, no, I agree with all of that, and I do think that, all of the concerns about the bad ones that might be out there, I think it is a separate kind of presence than the judge's presence, right? That there is something more human about what we bring into the room. And then I do want to talk about, we're available for hearing out the emotion. And some of us may be really good at that and some may be not great at that. But I think that is one of the things about that space. That if you are available for that, not only information is going to pass. I'm hearing you, Kelly, think of, sort of concrete information. Do you realize how many reports I have to write? I can't write, right? I mean, there's that piece, but there's also just seeing who this other person is as a human being, right? And feeling something very different about him. I mean, that opportunity, I think, is there in ways that when we think about the contrast to being in court, it's really kind of hard to come by. And I think that's really, really valuable. So people seeing each other.
So can so what you have said, what Michael said makes sense when I imagine everyone in the same room. But can we reliably even say that mediation is going to provide an opportunity for everyone to be in the same room?
Well, but I take what Art said, that we lose some things. I don't think there's any question. But I also don't think that there's nothing that happens when you're on Zoom. Right? I mean, I just sort of think about teaching on Zoom, right? I mean, there are definitely times when it's like, I wish I could be there in person because I would come right up on teacher Monica and say, how you doing there? Still there? And I can't even make you turn on your damn camera, no matter how many times I say, I like to see faces here. But when people buy in, there's some wonderful things that actually manage to happen. So I definitely lean more towards being in person, and if we can, I think there are really valuable things that happen, but I don't want to dismiss that when well done, and you have to do it, that there are some things that can happen in terms of actually people connecting even through the virtual.
And and it's interesting as you're saying that, yes, And I'm imagining people actually being in person, but in separate rooms all the way through. And that's the image I had in mind where I'm asking, you know,
So even there, I would say, Nancy, that, I think it's better if, you have people in the same room, at least at some part of the mediation. But even if they are in separate rooms, your presence in that room, people, I think there's a tendency to try to act reasonable in front of a neutral, right? To appear reasonable. And so I do feel like even if they're in the separate rooms, when you're interacting with them separately, there's a, I don't know how to say, there's a mitigation of maybe extreme behavior that they might not do if there's no, quite literally, moderator or mediator mediating the information back and forth. So it's better when they're both in the room, but I don't think there's still a benefit even when you have people in separate rooms.
so third-party presence, opportunity to exchange information, opportunity for that information not just to be about the facts, but also about the human element, the human issues and beings, and can still happen even if separate. Art first.
One of the things we found in our research is that some people have a goal of actually communicating with the other person. Like that's a specific goal that they want out of the mediation process. And we found that in those cases, people tend to get together, both in family and in civil kinds of cases. And just as an FYI, there's no statistically significant difference in outcomes of settlements, like whether it settles or not, if you get together or not. No difference whatsoever. Zero.
Very interesting.
I was gonna say something similarly. I think Kelly touched on it earlier when she said that it teaches people to work together in the future. So we teach people a better way to resolve conflict. And that's a reliable outcome, I think, of the mediation process.
Even if you're in separate rooms.
Even if they're in separate rooms sometimes, but I'm a joint session person. I'm an old timer.
Yeah, well, and you understand why I asked the follow-up
Exactly.
question. Okay,
Exactly.
great. And would it be fair to say, and one other, go ahead, Lisa.
Well, I just want to clarify what the conversation has been about today. I mean, I was a labor mediator for a while. We are not talking, none of this remotely applies to labor mediation.
Yeah.
Okay, I just want to take that off the table.
But actually, why don't you say why, I'm not in my head, but why don't you say why none of this remotely applies to labor?
Because labor mediation is political theater. I mean, you've got representatives who have been elected by people in the room. And these people in the room want to watch their representative articulate what they care about that's wrong with this institutional relationship on either side. And so it's political theater.
Actually reminds me much more of kind of the courtroom. Yeah, Michael.
There is a way, almost all of my mediations recently have been labor mediations, and there is a lot of political theater to it. But there is one thing that labor mediations provide that I think happens in a lot of civil mediations as well. Maybe this may not be a happy story, but mediation can provide an excuse to settle. A sort of a face-saving, it's the moment when now we can blame the mediator, or we can blame that we let go of the story that has perpetuated the dispute. I think that's something that mediation provides even in its bad forms. That also comes in a labor company.
And related to that, and it provides an event. And there's lots of research that shows just plain old having an event results in settlement. And would be fair to say, and as part of, how did I describe this? What the process reliably offers an opportunity to settle. I mean, because that is, that's the point in most instances. All right, so let me, unless anyone else wants to respond to that question, let me go to a different question. I would really be interested in knowing whether, and I think there have been suggestions today that there are some things that require further study. What do you really wish could be studied? What do you really wish could be studied? What information do you really wish we had, Kelly?
We just need more empirical data.
About what in particular?
Well, so one of the things I would like to see is we're going evaluative, we're going to facilitated settlement conferences instead of mediation in family cases. I want to see the satisfaction rates from the attorneys and from the clients, because when that's been done in the past, clients have liked more facilitative and attorneys have liked more evaluative. Is that still true? Is that anything that would lead attorneys to maybe not push for so much evaluative or to be in the default like Art's talking about? For my special ed, I want to see long-term, I want to see, is there really an impact from these mediations on children getting the services that they need? Are the services effective? That's a whole different thing, right? But are they getting the services that we have identified even? And there's just none of that studying going on.
Yeah, which, I mean, that's compliance, right?
Yep.
But very important information to have in terms of compliance. Let me ask a follow-up question, and Lisa, your ears, I think, will prick up in connection with this one. So when you ask about that we need to know whether the parties and the lawyers are satisfied, is that the same thing to you as asking whether they feel like the process was fair? Kelly?
Oh, I'm sorry, I thought you said Lisa. No, it's a great question. And no,
You care about that as much as caring about whether they're satisfied?
Did I say fair? I shouldn't have said fair,
No,
because
you
I don't
said
like the word fair.
satisfied.
I try not to use the word fair because everybody wants things to be fair and that means different things to everybody, right? So, I think their satisfaction rate numbers are important. But then that leads back to Art's discussion, right? Or the talk about Michael's about there's no complaints. Are they not complaining because they're satisfied, or are they satisfied because they don't know it could be any different?
Well, that's a real question. That's a good question.
At least I was heard a little bit.
Yeah.
Somebody listened to me briefly. That's more than I can get.
Because, you know, I want to do more on what are the racial, class, gender differences, which I know is going to be hard. I'm talking to Art about just all that he had to go through for what he's done, right? I know it's hard, but that would be the ideal. And I do think, and this is something we were talking about last night, you know, the satisfaction rates like you see in Herman's study, I mean, what does that mean? Are people settling, right? Because, you know, you go in front of the judge and it's kind of like, yeah, okay, this is it. And there's somebody who just says, oh, okay, yeah, okay. And now, but you still get screwed, but it still feels a little bit. To make Art just fall out in his chair because it's because I'm not doing it anyway. But I mean, you know, knowing what people would say, and some of that is really, if you know, I just want you to imagine a different world, and in that world, what would you really like? And then let's come back to the world that we're in. Right? So that we could try to capture some of the things that are about, I would like to not have to work 3 jobs, in which case I might have been able to come to a session around my special needs kids and really talk for as long as I felt like about what was going on. I would like, right? I mean, so I don't know how you do that, but those are the kinds of things that I'd like to know.
So funny as you say that, you know, the degree to which so often lawyers are saying what's really needed in mediation is to bring the clients back to reality, like not to allow them to engage in that kind of wishful thinking. Because that will infect the process and make it less likely to result in settlements. It's really interesting.
You know, and just to take up on that for just a second, which is we talk about establishing as mediators trust and rapport with our clients, and that you need that on some level, whatever that means. But when I've hear it all the time, attorneys don't trust their clients not to be emotional. They need to be in caucus because they don't trust them to focus on their things. But isn't that interesting that they don't work on establishing that trust with their client or preparing their client to participate in the process that their client really might want to, you know, in the case that you were talking about where they needed to be together. And so that's a frustration, right? Because we build up trust with the parties, so they'll talk to us and tell us things, but the attorneys basically are saying, we don't want to deal with the emotion. We don't want them to say the wrong thing. Okay, you could actually prevent that in most cases.
But isn't that kind of how we train them?
Well, I don't know what kind of we you're using,
Well,
but no.
When I say we, I
Yes,
mean, when you think about law
absolutely.
schools generally.
Absolutely.
Right? I mean, when I think, I mean, I'm back to teaching ADR, but I was teaching interviewing counseling and negotiation for a long time. And whenever I start talking about interviewing and, you know, a client says something crazy there, well, what are you gonna do with these impossible people? And it's, you talked. I think I'd have to withdraw if they said, well, no, you know, I don't necessarily have to do that. And I don't know, you know, I mean, I don't know that well, you know, I'm preaching to the choir here, right? We need more spaces for our students to be thinking in terms of how they're really interacting with people. And you're meeting them oftentimes in their worst moments, right? And so of course you're gonna have to deal with their emotions. Get used to it. Get still about it. You know, don't be defensive about it. Yes, they're gonna blame you because they can't, you know, do that to their wife, hopefully. They don't want to kick their dog. So yeah, just calm down and roll with it. We can work this out. But I know you guys agree.
Well, and you know, we don't spend a lot of time talking about the role of client counseling and interviewing in alternative dispute resolution. But I mean, it is a significant part of our field as well, but we don't spend as much time, I think, really focusing. All right, any other information that you really wish we had? Yeah, Lisa.
There is a whole gap, very few papers done. I did one, I'm not thrilled with it, on the relationship between the race or gender of the mediator and the race or gender and or both of the disputants. And one thing I found that I think is a training issue for mediators is in the Postal Service data, if it was a race discrimination case, and it was a Black complainant and a Black mediator versus a Black complainant and a white mediator, they were less happy, less satisfied with the Black mediator, which makes sense because there's an implicit expectation. This is one of my people and they're going to advocate for me. And the mediator has to be, quote, neutral. But I don't see why we should be training the mediators in that situation to be neutral or be perceived as neutral. I think this is a training issue.
What does that mean? Don't.
In other words,
Because we're very big on neutrality when we talk about the Singapore Convention. So what?
well, in the sense that if we thought, and the interesting thing was women who were filing sex discrimination complaints didn't care whether the mediator was male or female. It was
No matter the race?
This was just gender, not interactive.
We don't know what the race is.
Right. But they did care in a sexual harassment case. If the mediator was male, they were not happy about that. So, I mean, there are these issues about, can the person who's the mediator understand in a gut way my experience? And are they going to be able to communicate that for me, or are they communicating that for me? And expectations about who's going to do that. And the problem of what the mediator has been trained to do in terms of what's considered being a neutral third party. And I think this is not an issue that we've spent enough time thinking about or talking about, or how we go about framing it.
Yeah. I don't know how to frame it exactly, but yes. I mean, I even know that in the special education study that I did a long time ago, this doesn't have to do with gender or race, but the parents of special ed children very frequently did not see the mediator as being somebody who was going to facilitate negotiation, but somebody who was going to speak on their behalf more effectively than they could. So basically kind of seeing the mediator in the role of their advocate, or at least translate. Yes.
I would like to see more of our psychologists adding to our mediation training. My wife has a PhD in psychology, and she teaches about how to deal with people in conflict. She goes through the adrenaline, the heart rate, the amygdala, how logic is shut down in a second by fear and things like that, that we don't really get in mediation training. And when she trains judges and gives them that information, they go, wow, never thought about that. And she gives them words that they can use and skills that they can use to actually calm people down.
And interesting, because that also could be useful information in a client counseling and interviewing class, right? Right? Okay, yeah, really.
And we taught that just a couple of weeks ago. We judged a client counseling competition.
Cool, wonderful. All right, so we're nearly to the end. Is there anything that you think we need to do, we should do, that would help mediation achieve its potential? I'm going to share one thought that I had. I think this was as a result of the second and third panels. You know, I came into today thinking institutionalization, that's the problem. The courts, different agencies, corporations, they're the ones who are deciding to bring mediation in or to use mediation largely in order to save money. And that pushes the process in a particular direction. I still think what I just said is true. But at the same time, we've also talked about wanting mediation to the mediator panels to be more diverse, wanting to be sure that there are people who understand different perspectives serving as mediators, maybe wanting to include some of what you were just talking about. If then, for example, maybe there are ways in which we could use institutionalization. Are there leading organizations representing various communities of color that could provide some sort of badge of approval for certain mediation programs that have demonstrated that they really are working to provide mediation that will serve everybody? Are there certain businesses which are right now pushing law firms to include more diversity? Are some of those corporations potentially also ones that, if they were alerted to this, would be more likely to use particular dispute resolution organizations? Are there ways in which not just pushing against institutions, but figuring out how could we form alliances with certain institutions that would help move the field or the process in the direction that we want? That's a, not a fully thought through possibility, but just it was, instead of seeing institutions as, instead asking, are there ways in which we could use them? Yeah, Lisa.
Lord Charkoudian and the whole Maryland court group and community group. Lori did a really fascinating study where it was looking at the match between the mediators in each, right?
Yeah.
And this whole notion of having co-mediation models.
Yeah.
It might be a kind of best practice.
Very interesting. Very interesting. All right. Yes, Erin.
Maybe this is your earlier question. I really feel this need for somebody, some organization or some researcher to just get a big data set that we can all chow down on. I mean, because there might be different things that people are interested in, analysis of variance might show correlations that we're not necessarily thinking exist. And I think we have the processing power to do those things in a way that maybe we didn't 20 years ago. But somebody has to be willing to create the data set. And I feel like we get little data sets, or we make our own data sets by, Art and Roselle reaching out to people and painstakingly collecting this. But I mean, it would be nice that it wasn't just like a court system giving Donna Shatowski's data, for a county.
Yeah, it would be great if there, for example, the NSF would fund something to provide for that kind of a data set that then, I mean, part of NSF's rules are, then it has to be made available to everybody. It's an interesting idea. And then the question is, what kind of data would need to be collected? And what would it cost to get somebody to do that? Yeah.
See, one of the beauties and one of the problems is if you take a look at the Maryland data, they do small claims court and they make a lot of claims based on small claims court. And then everybody who doesn't do small claims court is like, but that's small claims court. Come on. all these differences that you highlighted earlier, and this definition of what is mediation is kind of expansive. That makes these definitional problems are huge in these kinds of data set assemblies. So not falling off my chair, but it's just hard.
Yeah.
I mean, Lisa luckily had people who were like, please help us.
And that data set can go, it's a question of whether it goes to the University of Michigan repository, and then anybody could play with it. It's 270 some odd thousand exit surveys over from roughly 1994, but they're through different models, 1994 to 2006.
We should talk about that possibility. All right, Cynthia, I think you're gonna be the last word.
I don't know if we're that, but
I'll be the last word. You'll be the second, to the last word. Okay.
So I think in looking at how to collect better data, I think one of the things that, Andrea and I looked at this in the context of criminal cases and the lack of criminal data. But the courts collect a lot of data, and it's not that hard to add some extra data points on, because there's things they've got to fill out and things they've got to send in, and the states are collecting stuff and the feds mandate collection of stuff. And it just, I just wonder if there aren't ways to do more through that. When we're talking about mediation, obviously a lot's happening that's not court connected, but a lot's happening that is court connected.
Yeah.
Right? And, we don't have too many laws that are mandating better data collection, but Florida was an example a few years back. But I just wonder, because we're relying on, folks like Art and, and Lisa from, all those years ago, collecting these wonderful and amazing data sets. It's not gonna be surveys. Right. And so it's not gonna be the qualitative stuff, which may matter more in some places, but I just wonder if we can't and shouldn't think more about how to use the existing structures and systems we have.
So I will just say that, this is something I actually have looked at, and the National Center for State Courts would really like it. If, for example, all the state courts were collecting the same data. Every state collects the data differently. Every state uses different terms. And you're also relying on clerks to input the data, and the clerks will say, I already have too much to do. I don't need 6 more data sets that I need to input. But the National Center for State Courts is really encouraging this. There is a project that has already been engaged in putting together what the National Center recommends as the data being gathered by courts, not just about dispute resolution, but also including dispute resolution. There are some states that are beginning to use their recommended data sets. And then I happen to know that a majority of state courts actually use 2 different vendors for case management. And at least one of those vendors is located here in Texas, and has indicated that they would be willing to include data entries regarding dispute resolution. It's just that they don't want to have to modify that for every different state court. They want it to be they want it to be uniform. So it's another issue of institutionalization. It's like 2 layers of institutionalization. All right. I wanted to say thanks again to all of you for being here. Thanks again to all of our presenters. And can we all clap really loudly for Kirsten Evans? I'm hoping is out there and heard us all clapping. Because then
Kirsten, did you hear that?
Also, thanks to the IT folks who helped us so frequently throughout today. And just Texas A&M in general, the dean and all of the staff who helped to publicize this, send out emails, etc. So again, thank you very, very much. Really appreciate your being here. Really appreciate the presentations. Thank you from me, because remember, this was all for me.